And defense? Morning.
And also Tammy Johnson, Mr. Thomas.
Thank you. Good morning, Mr. Tronnes. Mr. Tronnes, will you raise your right hand to be sworn?
Do you solemnly swear and affirm the
Oh,
testimony?
hold on. It's not raised yet. You just can't see. Will you raise your right hand to be sworn, please? Can you hear me? Yeah, I'm in a weird place for you. I said, will you raise your right hand to be sworn, please?
Do you solemnly swear and affirm the testimony you're going to give will be the truth, the whole truth, and nothing but the truth?
And you can actually put him at the table, please. Oh, okay. Okay. I don't mind if he's not handcuffed at the moment. Yep. Then, defense, are you calling Mr. Tronnes? And Mr. Tronnes, have you had an opportunity to talk with your attorney about the advantages and disadvantages of testifying versus not testifying? Did your attorney answer all your questions? I'm sorry? No, I said, did your attorney answer all your questions? Do you know that if you choose not to testify, I'll tell the jury that they cannot hold it against you? Do you know if you choose to testify, I'll tell them that they have to consider your testimony like any other witness? Do you understand it's solely your decision of whether or not you testify? And what do you want to do? Okay, thank you. Can we do jury instructions, please? Mr. Smith, these haven't been changed since the last that you sent to me? Is that correct?
That's correct, Your Honor.
Okay.
There's just I see a typo on statement of charges, just a small one, crime of first degree murder, not crime. I know it's petty, but.
Your Honor, do you want me to do the edits or you?
Will you please?
Yes. May I remain seated?
Of course. That way I can listen to the JOA after that. I'm having a hard time finding the jury instructions. Just give me a moment. Mr. Smith, will you send them to me again, please?
I got it. Sorry?
We will.
Yes, yes.
The last I have is October 12th. Are those correct?
I'm sorry, with all the coughing and everything.
I have October 12th, which was last Thursday.
I also sent them again on Monday, but it's the same instruction.
Okay, I've got them in front of me then. And as to the introduction of final instructions, state defense, any objection?
No, ma'am.
As to the statement of the charges, state defense, any objection?
Just the typo that I had mentioned, that I think Mr. J got, crime of first-degree murder. One word.
Thank you.
Thank you.
As to introduction to homicide, any objection, defense? Did you say no?
No, ma'am. Sorry.
And state, any objection?
No, Your Honor, you can assume there's no objection since I...
Thank you. First-degree murder, defense?
Your Honor, we would ask that heat of passion instruction be included, the basis being that the state produced no evidence of any kind of plan or purpose. There's also a lack of motive that's been demonstrated, which would only give rise to the heat of passion with legally adequate provocation.
State?
Your Honor, the defendant did not testify. There is no evidence before this court that this was done out of a heat of passion.
Defense?
Your Honor, I would ask that based on the circumstantial evidence that the court included.
I usually err on the side of including things, but if the state's strenuously objecting, I agree with the state. So, state?
There's been no evidence. We would be against.
Okay, I agree, then denied. As to lessers, I show second degree and manslaughter,
We're asking for both.
and any objection as to the second degree?
Only as previously stated with regard to legally adequate provocation, heat of passion.
Thank you, and same ruling, and as to manslaughter?
No objection.
Plea of not guilty, reasonable doubt, burden of proof. State, will you change the should to must on the last sentence? And any other objection, defense?
No objection to that, Your Honor.
Any other objections?
No.
Weighing the evidence. 6, money preferred treatment.
No testimony has been offered.
And I'm inclined to remove it. Any objection?
We are going very fast for somebody who even types as fast as I am.
Oh, sorry.
Weighing the evidence
We're on weighing the evidence.
and where,
Now you know why I asked if you could do it.
6 through 10, where,
6 through 10, defense, what do you want? Any of those?
Only 8.
Anything else? Defense, state? You want anything besides 8?
I agree. Probably not any evidence of 8, but no objection to making it 6.
All right, thank you. We could remove child witness, I believe. Remove defendant testifying.
Yes.
Any other objection through defendant not testifying?
No, ma'am.
Defendant not testifying, do you want the first paragraph, the second paragraph, or both?
Both.
Did you say both?
Yes, ma'am.
Thank you. Any objection to defendant's statements?
No, ma'am.
Eyewitness identification, I show it's been taken out, and that doesn't seem to be relevant here at all.
No evidence.
Thank you. Any objection to the rules for deliberation?
No, ma'am.
Cautionary and verdict? Any objection?
No, ma'am.
Submitting to the jury?
No objection.
Verdict form?
It appears appropriate to the defense.
Anything further, state?
Judge, we'll waive our request for the special jury instruction as long as there's no mention of it in closing argument about the polygraph or his willingness to take it or anything like that.
Defense? Agree? Sure. Okay. Then anything further as to jury instructions?
No, ma'am.
Then when you're finished, Mr. J, will you send them to my judicial assistant? Thank you. Mr. J, are you handling judgment of acquittal, or is Mr. Smith?
I will be.
Oh, sorry, that was the whole reason I gave it to you originally. Let me give you a few moments then. State, just let me know when you're ready.
I'm sending it now.
You are a fight.
Took time getting the defense attorney's email addresses into it, since I've only been back for 2 weeks.
I knew that. Are they the ones that I sent? Those are from April, August 29th.
I'm sorry, if you were waiting for me, I did send it.
You are finished?
Oh, yeah.
Then, thank you. Defense motions?
Yes, ma'am. For purposes of this motion for judgment of acquittal, as the court is aware, the state has rested. We're prepared to do our motion for judgment of acquittal. The defense plan is that we will also be resting in the presence of the jury, knowing that I have to preserve the argument on JOA should it not be granted or reserved. I would like to preserve that now without having to interrupt the jury. Your Honor, in order to prove first-degree murder, the state has to prove 3 elements, as the court is well aware. First, that Shanti Cooper-Tronnes is dead. Number 2, that David Tronnes was the one that did it through a criminal act. And then finally, number 3, that he did it with a premeditated design, with a conscious decision to do so before the killing. First, it's our argument that there's been insufficient evidence of premeditation presented to the jury for the jury to even consider premeditation. Dr. Utz, the medical examiner, testified that he couldn't determine whether she died from blunt force trauma or strangulation or both. His finding was both, but he also indicated during cross-examination that it could have been from one blow to the head, it could have been from the strangulation. But given the fact that he couldn't rule out the death resulted from one blow to the head, also given the fact that there's been no competent, reliable evidence of any motivation or any plan, we would ask the court to enter a judgment of acquittal as to first-degree murder. With regard to all the other types of murder and manslaughter for the jury to consider, it's the defense position that the state failed to prove element 2, that David Tronnes was the person who killed Shanti Cooper-Tronnes by competent substantial evidence. Here, this is a case that's devoid of any direct evidence that defendant was present at the time of the killing of Shanti Cooper-Tronnes. There's been no direct evidence presented of where the murder occurred. The testimony that the court has heard is that there was no blood spatter located. There was no evidence presented of a cleanup. While there is blood of the victim on the bed rail on the left side of the bed, there's no evidence of the time frame when that blood was deposited there. You did hear evidence that the victim was on her period, both through the interview of David Tronnes, as well as the fact that it was confirmed by the presence of feminine products in the trash through the testimony of Detective Sprague. There was evidence that there was menstrual blood deposited on the bed during the sexual activity that occurred the weekend prior to the murder. And FDLE Sean Johnson testified that you can't distinguish menstrual blood from any other type of blood. So the state has not demonstrated where the crime occurred. Second, there's no direct evidence and that there's no ear or eyewitness to the crime. You heard from the backdoor neighbor, Jacqueline Spence, who indicated that she didn't hear any screams, she heard no fights, she heard no argument, she heard no struggle at all whatsoever. There's been no ear or eyewitnesses to any admissions of the defendant. He was consistent with his story. He never made any admissions that he had any involvement in this crime. There was also no direct evidence of any weapon that had Mr. Tronnes's or the victim's blood on it. The state's theory is that he did this with his fists. Yet in the video and in photographs that have been presented to the court in evidence, you can see that on Mr. Tronnes's right hand, he was wearing a ring. That ring was never collected, it was never processed, it was never determined that that ring had any evidence belonging to the victim on the ring. There was no direct evidence in terms of any kind of video or photographic evidence of this crime. Again, there was no evidence linking him to any type of cleanup. All of the crime scene witnesses, Detective Sprague, were all asked about whether or not they found any evidence of a cleanup, any cleaning supplies, anything demonstrating that the crime scene had been cleaned, and nothing was collected, and there was no testimony to that effect. There's been no evidence brought before this court demonstrating any consciousness of guilt on behalf of Mr. Tronnes, and then finally there was no credible motive. With regard, and while the defense acknowledges that there's no motive isn't an element, there's no legal requirement to show motive, the motive is relevant in a case like this, where the testimony that the court heard is that they were happily married, that really none of the witnesses saw any conflict. It was repeated through the evidence that Mr. Tronnes has never had any kind of domestic violence accusation before in his whole entire life. So the lack of evidence of motive is relevant in this case. What the state has presented in terms of motive was that it was a financial motive, that Shanti Cooper-Tronnes was unhappy about the progress of the home renovation, that she was maybe pulling her money out, that she wasn't wanting to go forward, and that Mr. Tronnes had some type of financial motive to kill her, either so that she wasn't pulling out or that he was going to have free access to all of the finances in order to continue the renovation of the house. But that's not what the evidence showed. What the evidence showed was Shanti was happy about the show. She was happy about the involvement. She was happy that things were getting ready to progress. You heard that through Lori Kutcher. You heard that through Samantha Adams. There was really no evidence to the contrary. The production was set for May. This crime occurred April 24th. So in just days or weeks, production was going to start. So even though there had been a significant time where nothing was happening, I mean, what the evidence showed was there was something happening. From January until sometime in February or March, production was going forward, but all of a sudden Keith Ory, because of the spots that they needed for the show showing demos, said we have to stop. We can't move any farther forward, but that was going to restart in May. You heard testimony that in his own separate accounts that David Tronnes really had enough money to finish the project. There was evidence that he had at least $250,000 in his own singular accounts, separate and apart from Shanti Cooper-Tronnes. Their joint accounts had over $300,000 in them. And this house, even in the state of disrepair, was worth a lot of money, even if the repairs didn't go forward. And you've heard no evidence to the contrary. And then finally, with respect to the lack of direct evidence, there's no direct evidence pointing a finger at Mr. Tronnes from the forensic evidence. Again, the state's theory is that Mr. Tronnes used his fists, his hands, to punch Shanti Cooper-Tronnes, and then he strangled her to death. There were 3 search warrants conducted on that residence. In any of the 3 search warrants, there was no blood spatter found. The medical examiner, Dr. Utz, testified that these injuries that occurred to her face would have created a lot of blood. He said that those areas, the cheekbone, the ear, they're very vascular-rich areas, and so there would have been a lot of blood. Yet, there's no blood spatter. The court has had an opportunity to see the photographs. This is not a huge space. The area where the state, through Detective Sprague, said this happened on the left side of the bed, there's an end table. There is a mirror. There is a headboard. Immediately adjacent to the nightstand is her workspace. And if you look at the photographs, immediately to the left of the nightstand, there is a mouse pad. The mouse pad still has the mouse sitting on the mouse pad. No blood spatter on that surface, no blood spatter on the nightstand where there is a bottle of lotion, a L'Oreal night cream, a watch, a singular earring, and a water bottle. No blood spatter on that surface, and as a matter of fact, no sign of any struggle. The water bottle is still standing up straight, and it's only maybe a third full of water. So if this happened there was not a struggle because the water bottle is still standing. There's no blood spatter that was ascertained on the headboard of the bed, no blood spatter on the mirror above the bed. The only blood evidence in that location is the blood along the blood rail, which I think I've already indicated in my argument. The state never established the time frame when that was deposited, but if you look at the photos and you look at them closely and you look at all of the photos, not a singular photo taken from the right side of the bed that kind of gives a deceptive angle to where the blood stains were, there is no blood stain directly below that bed rail. The blood stain, and what you'll see in the photographs, is that the only blood that they located on the floor is where the mattress pad was, where the victim's body lay at the time that paramedics, first responders arrived. When that mattress pad is removed, what you're going to see is there's a little bit of blood stain at the bottom, a little bit of blood stain at the top that kind of pooled out because, as the court has heard, this was draining blood that was also diluted blood because her head had been in the bathtub. There is no evidence that blood dripped down that bed rail onto the floor. And if you look at the photographs, even the area where they removed the carpet, there's no blood. It's to the left of that left bed rail. So again, no evidence in 3 search warrants of any blood spatter. Evidence of blood being in the bathtub, which is where Mr. Tronnes said that he found the victim, but really, other than where the drained blood was deposited, no other blood on the crime scene. There were no injuries to the defendant. The court has had an opportunity to see those photographs. The only injury that they are able to even document is on his left hand. There is a small scratch of about a 1/4 inch long that's well closed, well healed, and equally consistent with what he said he did every day, which was trim the bougainvillea bushes from over the driveway, work with the plants around the lanai. Definitely not consistent with punching someone in the face so hard that you split a cheekbone or that you almost sever an ear. No other injuries to his hands. You saw on the video interview of Mr. Tronnes, they even had him take down his entire upper clothing, the paper suit, the Tyvek suit. They had him stretch out his arms. They had him flip his arms both ways. They had him put his head down. They had him put his head up. No injuries found anywhere on his body consistent with the struggle that took place in that apartment. There was no DNA on the victim's neck or throat. And Sean Johnson, the FDLE analyst, testified from the stand that, you know, if you do something like this, there's going to be a lot more DNA than if you just touch it. Choking someone to death, Dr. Utz described how it doesn't happen like it happens in the movies. There would have been a sufficient contact with her neck and throat that if David Tronnes's DNA were there, it would have been located. No DNA on her neck and throat matching that of Mr. Tronnes. In the photographs of the victim, no broken fingernails. Her manicure is absolutely pristine. Dr. Utz testified about some linear marks that were on her neck that he said were consistent with if a person is being strangled or choked, that she would have been potentially trying to remove the fingers of the assailant from her neck, yet her fingernail clippings were collected at the medical examiner's office, sent to FDLE, tested by Sean Johnson, and none of the defendant's DNA was under her fingernails. The sheets. The blood on the sheets, 35 areas between those 2 sheets that were identified for any kind of spots or stains. Only 2 of those 35, which were tested, it might have been more than 35. That's where I lost count. So I apologize if that's an incorrect number, but it's somewhere around that. It's at least that. Only 2 of those stains came back to Shanti Cooper-Tronnes. And it was gone over in the defendant's interview. And it's really not controverted that there was some sexual activity that involved menstrual blood. Again, the menstrual blood was confirmed by the feminine products in the trash can. Absolutely consistent with innocent and normal daily use of the sheets. Of the other stains, there were numerous stains coming back to Mr. Tronnes. Detective Sprague testified yesterday herself that those places in the bed where his blood were, I mean, again, he had no injuries that would have created blood other than the sores on his back from the food allergy or the allergic reaction, bug bites, that Detective Sprague said these weren't involved. They weren't injuries resulting from the struggle. And then the other stains came back to Jackson, the child. So all of these stains on the bed sheets really don't point to any kind of crime happening at all whatsoever. There was the blood on Mr. Tronnes' pants. I don't think that they were able to get a direct result from the back of the pants, but the stain on the front of the pant, very small stain, absolutely consistent with his story, which was that he struggled to get her out of the tub, she's bleeding, and then he attempts to see if he can revive her. So it makes perfect sense that her blood would be on the clothing that he was wearing. It's a completely innocent inference, does not suggest guilt. And then finally, there was the latent print evidence. All that demonstrated was that Mr. Tronnes was in his own bathroom. Doesn't demonstrate anything else. It's consistent with what he told detectives in the interview about finding her in the bathtub, attempting to remove her from the bathtub so that he could try to get her help. So through all of the forensic evidence, there's absolutely no direct evidence that Mr. Tronnes participated in the crime. So the state's case is entirely circumstantial. And when the evidence is not only consistent with guilt, but also, the state can only convict based on circumstantial evidence alone when they can't refute the defendant's reasonable hypothesis of innocence. So that comes from Jaramillo v. State, 417 Southern 2nd, 257, as well as Shadowin v. State, 362 Southern 2nd, 398. I've provided all my case law to the court ahead of today's hearing, as well as to the state attorney's office. The defense argues that the circumstantial evidence offered for conviction presents an equal possibility of innocence to the possibility of guilt. What we have here, Your Honor, is we have a case where the circumstantial evidence does nothing to refute the defendant's reasonable hypothesis of innocence. He gave the court his timeline when he gave it to law enforcement in his interview. He said he got up that morning, checked on Shanti. She came downstairs sometime between 7 and 7:30. She smoked a cigarette. She said she wasn't feeling well, wasn't even sure she was going to her dental appointment. She was going to lay down and see how she felt. Mr. Tronnes went about his business doing what every witness told the court that he does. Deals with the dogs, works on the house and the yard, stays out of Shanti's way. The state points to her health app. Now, there was no evidence that Shanti Cooper-Tronnes was wearing any type of Fitbit or Garmin or exercise tracker, something that was on her body that would have tracked her steps. This was a health app that was on her phone, and as a matter of fact, in the photograph on the nightstand, you can see, I think it's a Fossil watch. It's some type of watch, not a step tracker. There was no evidence that she had any kind of step tracker on her phone, so the only time that that phone would have registered a step is when she was carrying it as she was walking. There's no evidence before this court that she ever picked it up that day. So it wouldn't have registered a step. That evidence is consistent with Mr. Tronnes' reasonable hypothesis of innocence, which is that she was tired, she was laying down, she was going to continue to nap to see if she could feel better. It's not reasonable to expect that she would be walking around with her phone. Her phone, as you can see, is on the nightstand on that table. The state also points circumstantially to the fact that David never called or texted her. Well, Your Honor, there's been no evidence presented to this court that that was unusual. They had his phone, they had her phone. If there was evidence that they're texting, they're calling every day, that could have been presented in front of this jury, and it was not. What you did hear was, and you heard this from Samantha Adams, that Shanti was, and this is what I wrote down that she said, not open to outside communication when she was working. And that fact is borne out also by Keith Ory. He testified that it was really hard to get an appointment set down, and that when he did schedule an appointment to meet with both David and Shanti, Shanti came down the stairs with her headset on, heard what he had to say, and back she went. So the state's argument that it's unusual in some way that Mr. Tronnes didn't text or call his wife all day long is not inconsistent, and it's really not, doesn't point to a crime, doesn't imply guilt. Mr. Tronnes told law enforcement that he went for a walk. I think he testified that he went toward Orange, came up around Lake Lucerne. I can't remember which order the lakes are, but then Lake Cherokee, Lake Davis. He said that it would have taken him probably over an hour. And that walk is confirmed by the state's own witness, Jacqueline Spence, the backyard neighbor. My recollection of her testimony was that she saw him when she was leaving to go to, I believe it was Publix, and that was sometime between 10 or 11. She saw him, didn't see anything unusual, saw no blood on him. There was no testimony that she saw any blood on his person. And I think that the testimony was she arrived at Publix sometime around 11:15. Consistent with Mr. Tronnes' timeline and what he said he was doing that day. She said he was walking west on Miller toward Orange Avenue, which is consistent with the path that he said he followed. He said he was gone for an hour and 15 minutes. He came back. He did what he does. Cleaned the pool, trimmed some bushes. He then takes the dogs out for a walk, fed the dogs at some point in time during that time frame. After he takes the dogs for a walk so that they can do their thing, he loads them into the RAV4, drives to Park of America to play with the dogs, which he said he had already discussed with Shanti, so no need to text her to say, hey, I'm going to the dog park. They'd already discussed that. So he says that while he was there, he worked the dogs pretty hard, probably for about 45 minutes, that he physically worked the dogs at the dog park, and that he returned to the house at about 2 o'clock in the afternoon. There's no evidence to the contrary. Detective Sprague said she, tried to get video to either confirm or deny that, and it just wasn't available. No fault of Mr. Tronnes. There's no cell site data, no location data that shows anything to the contrary of what he said his story was, which would have put him outside the upstairs loft of the apartment from probably about 8:30 in the morning until sometime after 2 o'clock. He says when he returned, he did more of the yard work and the things that he does, and at some point in time during that time frame, he also went into the residence to do some measurements. He indicates that he has to drag her. He's unable to lift her, so he has to drag her to the area where she was ultimately found, which was on the left side of the bed, between the bed, the workstation, and the sofa. That accounts for the drag marks on her knees. And if you look at those drag marks, there's not a significant amount of blood in those drag marks, which would tend to indicate that at the time that he drug her, that she was already deceased. After realizing he can't revive her, he calls 911. None of the forensic findings, none of the findings in the crime scene are inconsistent with that. There's blood on the mattress pad and the carpet. That's what you would expect when a person trying to revive a person who has been attacked places them on that area. The blood that had been pooling in the tub is now draining from her body and her hair, creating the blood spots on either side of that mattress pad. The medical examiner, Dr. Utz, testified that the petechiae in her eyes could occur from positional asphyxia, and he described how that sometimes occurs when a person, because maybe they're unconscious or something along those lines, is not able to move, so they can't move their diaphragm. And he described that it can occur like in a car accident, or when a person, he described an intoxicated person falling, hitting their head, and then slumping over something like a toilet or a bathtub, and not being able to move their diaphragm in order to breathe. He said that that could cause petechiae, that could account for the blood in the tissues of the eyes, that it could just be from being in that prone position for a period of time. It could also account for her positioning from the slight rigor that had started to set in her arm that was lifted and flexed. And then we have to talk about the timeline. So, the report that's in evidence from Ralph Kalachi that he said he completed prior to leaving shift that night, which was before 10 o'clock at night. He wrote on that form that he found that, and he's trained. He's the person who's had the experience. He has had training both prior to and at the medical examiner's office in order to be able to make these reports for the benefit of the doctor doing the autopsy. He says there was mild rigor. Dr. Utz said that that was indicative of a person who's been dead for as little as 1 to 2 hours. Ralph Kalachi in that report also stated that livor mortis was unfixed, meaning that it hadn't, the pooling hadn't finished settling. And Dr. Utz testified that livor mortis starts within 20 to 30 minutes of death. If you look at the photographs that are in evidence, when investigator Crosby took the photographs of Ralph Kalachi rolling the body over, there's very little livor mortis even visible, meaning that there hadn't been much time for the blood to pool. And then you heard from Dr. Utz, who testified that when he did the autopsy the next day around 10 o'clock a.m., that while he couldn't be certain, he would have estimated that the body had been dead for not more than a day. So that puts our timeline, Your Honor, directly within the time frame that David Tronnes said that he was gone from the house, sometime after 9 o'clock, but obviously before he arrived at the house. Sometime between 10 o'clock and 11 o'clock a.m. on April 24th, 2018, where does the state's evidence put David Tronnes? Walking west on Miller toward Orange Avenue, the very path that he told detectives that he took. Citing to Davis versus State, 90 Southern 2nd 629, a Florida Supreme Court case from 1956. Starting on page 631, Evidence which furnishes nothing stronger than a suspicion, even though it would tend to justify the suspicion that the defendant committed the crime, is not sufficient to sustain a conviction. It's the actual exclusion of the hypothesis of innocence which clothes circumstantial evidence with the force of proof sufficient to convict. Circumstantial evidence which leaves uncertain several hypotheses, any one of which may be sound and some of which may be entirely consistent with innocence, is not adequate to sustain a verdict of guilt. So that's where we are, Your Honor. This is an entirely circumstantial case. The state has wholly failed to prove David Tronnes' reasonable hypothesis of innocence, which was told to Detective Sprague and Detective Sharp immediately after this man located his wife and called 911. Davis goes on to say that even though the circumstantial evidence may be sufficient to suggest a probability of guilt, it is thereby not adequate to support a conviction if it's likewise consistent with a reasonable hypothesis of innocence. All of the state's case is reasonably, it has the same support of innocence as it does guilt. It doesn't disprove his hypothesis of innocence. The circumstances in Davis are factually similar to our case here. Mr. Davis was accused of murdering his wife. The allegation there was that Davis's wife died at about noon. His whereabouts were unaccounted for during the time. I'll get to the facts and circumstances of the cases in support. Here.
State defense, will you approach?
Sure. Turning to Chowdhuan versus State on page 3. Circumstantial evidence is not sufficient when it requires the pyramiding of assumption upon assumption in order to arrive at the conclusion necessary for conviction. Cites also to Gustine. Your Honor, here the state is asking the jury to make a great number of assumptions. They want you to assume that David washed the body based on his palm prints being on the bathtub where he lived, the only bathtub in the house. They want you to assume Shanti's blood under the bed rail is from 424, despite no blood at all whatsoever on the mattress, as evidenced by the photographs and the testimony before the court, and no blood pooled below that bed rail. They want you to assume that he either cleaned the body or he used a towel to strangle her to explain the absence of DNA on her throat. However, the towel was under the mattress pad, under the body, not consistent. They want you to assume that he cleaned a crime scene to remove evidence, but provided no direct evidence of that. They want you to assume that he discarded clothing that should have been covered in blood, but provided no evidence of that. You heard that they even tested the washing machine for blood, which had been fruitful in other of Detective Sprague's cases, but there was no blood in the washing machine, and they found no other clothing. They want you to assume that because the sheets were washed and folded and placed on a shelf and later removed, that suggested guilt. They want you to assume because there were new sheets that he was hiding incriminating evidence when those sheets were present in the video that the state put into evidence from April 18th. Those sheets could have been purchased by Shanti herself. They want you to assume because his engagement ring is found in his personal belongings 127 days later, that suggests some kind of wrongdoing. I'm just going to address that very quickly, Your Honor. The ring was not on Mr. Tronnes' person. We know that because they took every bit of clothing that he had on him and left him in a paper suit for 14 hours. No ring with him at the police station. And the testimony has been that they looked through absolutely everything on 3 different search warrants, specifically looking for that ring, and were unable to locate it. But even so, he didn't sell it. There was no financial motivation. And it really is not material. They want you to assume that because he wasn't crying throughout the 10 hours that he was in the interview room, and he didn't react the way that they felt appropriate, that he is somehow guilty. And Your Honor, these are pyramiding circumstantial evidence, none of them inconsistent with a reasonable hypothesis of innocence and not sufficient to convict. And we ask that you grant him a judgment of acquittal.
Thank you. Spot and state.
Judge, first of all, the legal standard is not what has been stated. The legal standard under Bush versus State, a Florida Supreme Court case, 295, Southern 3rd, 179, if I may approach.
Thank you.
There, in that case, the Florida Supreme Court acknowledged that Florida was an outlier in the use of this unusual circumstantial evidence standard of eliminating every reasonable hypothesis of innocence, eliminating negatives, essentially, which was unfair, and they changed that. The standard is now what most jurisdictions have, and that is there competent and substantial evidence to support the state's theory? Even if there are other theories that are supported by competent and substantial evidence, that is fine. It is for the jury to decide whether A, the state's theory, or B, some alternative theory, if supported by evidence, is to be believed beyond a reasonable doubt. Even if we're applying the old standard, it is unclear what the reasonable hypothesis of innocence might be in this case. The reasonable hypothesis of innocence presented in the evidence is that she fell, according to the defendant. She had fallen in the bathtub, and he discovered her several hours later. Or is this imaginary hypothesis not supported by the evidence that a random person came in through the main house, scaled the ladder, crossed the rooftop, got in through a locked door without alerting the victim, killed her, took essentially nothing, and locked the door behind him or her and left? Your Honor, taking every inference in favor of the state, which the court must do at this time, there is a prima facie case. And I will not address every point that was raised. It is more appropriate for closing. But some of the things do need to be addressed because of the inferences that should be drawn from them by the court. There was an argument that there's no evidence of a cleanup. There are 3 areas of blood in this home, and all of them are diluted with water and swiped away. Whether it's the wooden bed rail, which was wiped above the metal L, and then the non-visible blood behind the metal bracket and underneath it, and then on the wood slabs was left remaining. Whether it's the water that is evident in the photographs only around the blood stained areas on the carpet surrounding the victim, and the bathtub where towards the end of the argument, there was an argument made about the bloody fingerprint. Well, handprint that she stated, but it's a bloody handprint amongst the diluted blood on the wall. There is an inference that that bloody handprint was left after the blood was there. Briefly, their relationship status, not particularly relevant. Couples, intimate partners fight all the time over all sorts of different things. Finances, again, some evidence has to be presented to the jury just so that the defense can't argue that it wasn't. But this poorly planned and executed beating and then strangulation of his wife and failed cleanup probably was not the best plan if this was his plan for money. The state's theory, whether there's a weapon or not, the testimony was that it's consistent with a punch with a ring on the finger. That is not the exclusive theory that the state has available to argue. The issue of the spatter, the only testimony about spatter was from Gary Crosby, and the difference between high velocity and low velocity spatter. But then we turn to the argument that there's no spatter, yet there's cleaned up blood on the carpet in front of her, which is where there could have been spatter had she been on the side of the bed, if in fact there was spatter. There's basically 2 square yards of blood-stained carpet that has been removed after being diluted with water. So the issue of the blood, all the inferences are in favor of the state. There's no evidence that one would become injured from a punch to a 140-pound woman's cheek with a ring on your hand. So to argue that he should be injured has not been entered into evidence. No evidence of a struggle. That the state would agree. I think the inferences to be drawn from the evidence, her body and the surrounding evidence, is that she was attacked and had no chance after being struck in the head multiple times. Dr. Utz even testified she could be rendered unconscious from these injuries. Dr. Utz testified that those injuries were perimortem or before death. So while she could have ultimately died from those head injuries, is what he testified, she was also strangled. And the strangulation would have occurred afterwards, or else the injuries to her head would be post-mortem. In essence, this is a circumstantial case, but the circumstances of her body and the scene are inconsistent with the defendant's version of events. That makes it a jury question. There's a jury instruction that if you disbelieve any part of a witness's statement, you can disbelieve all of it. And there's very little other than saying that her jaw was rigid and her tongue was stuck between her teeth to be believed from his 6-hour statement. So we're asking you to deny the motion of judgment and acquittal. Thank you.
Thank you. And the court denies the motion for judgment of acquittal. How many jurors do we have? We have them all? We can bring them out. I'm sorry. What day is that? Okay. Yes, they're already on their way out, but you're welcome to take that time. Morning. Thank you for being so prompt today. State, do you recognize the presence of the jury?
Yes, Your Honor.
Defense?
Your Honor, thank you.
And members of the jury, were you have you been each able to follow all the instructions I've given you as to this point?
Yes.
Defense?
Your Honor, at this time, having pled not guilty, the defense would rest.
Both the state and the defense have now rested their case. The attorneys will have an opportunity now to present their closing argument. Please remember what the lawyers say is not evidence, nor your instructions on the law. However, listen closely to their arguments. They are intended to assist you in understanding the case. Each side will have an equal time, but the state's entitled to divide this time between opening and rebuttal after the defense has given its closing argument. State ready to proceed?
Yes, Your Honor, if I can just have a moment with the evidence.
Yes, sir. And defense ready to proceed?
You are. Thank you.
State, whenever you're ready, you may proceed.
Thank you, Your Honor. May it please the court.
You may proceed.
Crocodile tears and a story that doesn't make any sense. That's what this defendant had after the brutal murder of his wife, Shanti Cooper-Tronnes. So you've now seen all the evidence in this case. You've heard the testimony. After closing arguments, you'll be able to take that evidence back into the jury room with you. You'll be able to review it as you would like to. But there's one big distinction as we sit here now from when I first spoke with you on that opening statement, and I want to point that out to you. So there was some discussion in jury selection that the defendant has a presumption of innocence. He sat before you in jury selection as a presumed innocent man. After opening statements, you've still seen no evidence. He sat before you a presumed innocent man. You've seen all the evidence now. And that presumption, that cloak of innocence has been ripped away by evidence in this case. And he sits before you a proven guilty man. Now, I want to go back through with you the evidence that you've heard in this case. The judge is going to give you an instruction called weighing the evidence. And you're going to have that with you in the jury room, but I want to talk to you about that because this is sort of the lens that you will watch or review all of the evidence through. You'll have this instruction, but I just want to point it out. So when you're listening to testimony, you're looking at evidence, these are the things that you're to look at when you're going back and you're thinking in your mind what the witnesses said. Did the witness have an opportunity to see and know the things that the witness testified about? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's question? Did the witness have some interest in how the case should be decided? Does the testimony agree with other testimony or other evidence in the case? And did the witness at some time make any other statement inconsistent with the testimony given in court? So these are the things that you're to look to. So I want to talk about what you've heard and how the witnesses that testified did have an opportunity to do these things. And you've been able to observe that through their testimony. So The first witness that you heard in this case was Cynthia Demetris. She's the 911 operator. And she was called so we could put in the 911 call with the initial crocodile tears of the defendant. And you heard the hysterics that he had in that call. You know, unintelligible. You can't hear what he's saying. But then when asked direct questions, how do you get to the house? Well, he's able to calm himself almost immediately and say, you go behind a dumpster and go to the side of the house. That's how you get to it. The show that he was putting on at the very beginning of this case, in that 911 call, you heard that. You heard from the responding officer, Stephen Wilson, as well as the responding EMT. You heard how when they arrived, they thought they were walking into some sort of an accident. But when they got there, they realized that this was something very different. They saw the extent of the injuries to Shanti Cooper-Tronnes, and they realized very quickly that this wasn't some fall in a shower, that the evidence that would be unfolded throughout the case, even at that point, didn't show that. Rigor mortis was already sitting in. You heard from Stephen Wilson. He told you that while the defendant was hysterical, screaming and appearing to cry, that he didn't see any actual tears during the time he was on scene. You heard from Mary Batista from Greenberg Dental. She explained to you how Shanti Cooper-Tronnes had made an emergency dental appointment just the day before for a broken tooth. A broken tooth that if you're trying to get into the dentist that quickly, probably was causing quite a bit of pain. And that how the next day, after she made that, Shanti Cooper-Tronnes never called and said she wasn't coming, and she was a no-call, no-show. You heard from 4 different CSIs in this case, and a lot of evidence that sits before you here was put in through those CSIs that they collected, that they photographed. And you got to see those photos of the scene of the Tronnes home. You'll be able to review them again in the jury room if you so choose. You saw the physical evidence that they collected. You saw the scratch on the defendant's finger next to his wedding ring that the medical examiner said would be consistent with something that could cause the deep laceration seen on the victim's face. They documented the blood on the carpet in the bathtub, collected fingerprints and DNA. You saw that they collected cash that was all over the place, credit cards that was all over the place, not touched, electronics that were valuable, not touched. So there was no signs of forced entry. They collected a diamond earring from the nightstand, and then another diamond earring from the medical examiner that was still in her ear at the time that she died. You heard from Lori Kutcher, a friend, colleague, and mentee of the victim. She told you about Shanti's diligence, about her quick responsiveness at work, how she trained her, in fact, that being responsive to clients is of the utmost importance. She told you about how Shanti was proud of her engagement ring and that she never noticed her not wearing that ring. You saw a Facebook post of that ring from a little before a year before her brutal murder. And you saw this ring itself, which is in evidence, that was found at the defendant's mother's home where he was staying. You also heard from Lori Kutcher, and she told you about how she came by to check on the defendant after the murder on April 26th. And during that time, the defendant told his version of what he knew. But at that time, the defendant had already sat down for 6 hours with law enforcement regarding this case. And towards the end of that interview, the defendant was told this wasn't an accident, was told some of the scope of the injuries, was told that the victim was strangled, but none of that was mentioned by the defendant to Lori Kutcher. That he was still going with some sort of accident. Even though he knew that information, he concealed it because it didn't fit with his narrative. You heard from Jacqueline Spence. She was a short witness in this case, but very important. She was a neighbor of David Tronnes. She recognized him from the neighborhood. She had interacted with him some in the past. And she saw him walking around the neighborhood around 11:50 a.m. on the day that the victim was found. Now, he had said in his statement that he was going to the park at that time, around 11:45, with the dogs. And he had stayed there for almost 2 hours. But at 11:50, when he was supposedly walking the dogs to the park, or with the dogs on the way to the park, what was he doing? Well, he was walking by himself with different clothing on, no dogs. You heard from Dana Duran, the victim's college friend. She told you about the rocky nature of the defendant and Shanti's relationship. She said that sometimes she would have to act as a mediator in that relationship. She said a lot of the tension and the struggle there was related to this construction or destruction of the home that they were living in. And she told you Shanti could make cutting comments. You know, she was a tough woman, and she wasn't one to just sit and take it. She could be cutting. The defendant felt that. And she also told you that the defendant, even though knowing they were best friends after the murder of Shanti, never called her and told her anything. So with Lori Kutcher, he told his version of events. With Dana Durand, he didn't say anything. You heard from Keith Ory of the zombie house flipping show, and he told you about the state of the house. I mean, this house was like nothing he'd ever seen before. Completely gutted. He'd seen it a few months before. It was sort of a standard demo, but then, a few months later when he was called back out to look at it, it was like nothing he'd ever seen before. He had to bring engineers in to look at it to see if it was even structurally sound enough or safe enough to do any kind of work on it. It was held up by 2 inches of stucco. Ultimately, you heard from Mr. Ory that he did decide to work with David on the project. It was something that interested him because, again, he'd never seen anything this bad as far as the destruction of a home before, and he agreed to sign on. And because of the unique nature of that destruction, he thought it would be something that could be interesting to people on his show, Zombie House Flipper. But obviously, at the time, they were in between seasons, he explained to you, and so we had to see if the logistics of that would work out. So he begins to organize some work on the Tronnes home, and then in the interim, the show's renewed. So then, as they just started back, and it looks like that they're going to get some movement on getting this house back into a livable condition, then he has to have the conversation that, look, you have the opportunity to be on this show. There's some benefit there. There's some trade-out that could be worth between $20,000 and $30,000. But construction's going to have to stop, and you're going to have to essentially live as you're living for a few more months. And the Tronnes agreed. Obviously, based on his own interaction with Shanti, this wasn't something that she was extremely excited about at the time. He explained to you that he required a sit-down meeting with the Tronnes to go over, everything that's involved in being in a show of that nature. And first it was difficult to schedule that meeting, but then when he finally was able to set it up, Shanti was not into it. She came downstairs, she had her headset on, she was dismissive. He said he noticed a clear tension there. Shanti's demeanor was different at this point, a week before her murder, than it had been the several other times that he'd interacted with her related to the home. Something was different, and he noted it. You heard from Billy Lane, a private investigator who took bloody sheets from the defendant's home that was ultimately taken to a locker and recovered by Detective Sprague and CSIs about a year later. You heard from Timothy Whitehurst, and he was a quick witness, but the purpose of Timothy Whitehurst was just to explain to you, Shanti had an ex-husband, Jim Cooper. Sometimes there's a inclination, and Detective Sprague testified that an ex-husband is also a suspect initially in any kind of a murder of someone. But Jim Cooper was working with him the whole day of the murder. He was over in Tampa from early in the morning to the afternoon. So Jim Cooper, had an alibi as Detective Sprague went through her checklist of crossing things off in her investigation, did a thorough investigation. Jim Cooper didn't have anything to do with this. You heard from Adam Frank, a forensic accountant that we hired. And he went through the defendant and Shanti's financials. And he told you that between Shanti's accounts alone, and then accounts that were held between Shanti and the defendant, that at the end of March of 2018, that there was over $800,000 in those accounts. And that's not including the $350,000 life insurance benefit that the defendant stood to receive at Shanti's death. You heard from Patrick McCarty, the life insurance rep that set up that life insurance policy, that Shanti had the $350,000 policy, that actually, up until 2017, the beneficiary was her son Jackson. But then in 2017, after the marriage, the beneficiary was changed to the defendant. You also heard from Patrick McCarty that at the same time that the life insurance was changed, the defendant was made the sole beneficiary of all of her investment accounts. You heard from Barbara Sharp, assistant detective, violent crimes at the time, now a homicide detective, how she assisted with Detective Sprague in the investigation, how she went to the different scenes, and ultimately, she was the person who, in the August of 2018 search of the defendant's mother's residence where he was living, found in the defendant's room, in his suitcase, Shanti's engagement ring. You heard from Amanda McHugh, the fingerprint expert, how she herself rolled the defendant's fingerprints. She took possession of fingerprints rolled by CSI Kane, and she used those rolled fingerprints and compared them to the latents that were able to be lifted from the Tronnes residence. Now, there was 6 different latent impressions that were able to be rolled from that residence. And bear in mind that when these prints are pulled up, the CSIs have no idea who, that they can't look at it and say, oh, this is, the defendant's prints, or this is the victim's prints. They're just, they look like an area of latent prints, so they roll them up and they see what it comes back to. They don't control or have any idea who it's going to be when the CSIs take it. So they take these prints back, all the latents that they're able to pull, and they give them to Amanda McHugh to compare, and every single one of those latent prints comes back to either Shanti Cooper-Tronnes or the defendant. No other person. You heard from Randall Pennington, who works with the Orlando Police Department in digital forensics, how he took possession of all of the digital forensics that was found at the initial scene, the phones, the computers, and how he took them to a secure location to be downloaded by Robert Woodyard, who's also in digital forensic and did the processing of these phones, these computers, and things like that. From Robert Woodyard, you heard of what was able to be pulled from the phones, how you saw the video of the defendant giving essentially a walkthrough of the house shortly before the murder of his wife. And you saw she's come down the stairs, he's narrating the video, she's dismissing. This is the same tension that Keith Ory saw the week before the murder. And you can see it in that video that the defendant himself took. He processed information from the victim's phone as well as the iCloud account. And you saw, and you'll have with you that you can take back the incoming phone calls, outgoing phone calls from the day before and then into the 24th, or when the victim was found. see in the records that the victim was able to have with her son around 8-ish at night. There's some other activity that you can see on the phone, but as you get to 11:30, the night before she's found, everything stops. No more outgoing phone calls, no more outgoing text messages. She's not moving anymore. Obviously, perhaps you go to bed, you set your phone down, so you're not moving at night, but you heard from all the testimony, you'll see the evidence from the phone of her normal activity. She's up and working. She's a business person that works, some people said almost 24/7. But at no point on April 24th does that phone that had been showing movement previously at those times, at no point does she take any steps. Does she take any stairs? Nothing. You heard yesterday from Daniel Connolly, who worked with Shanti. He again told you about her quick responsiveness, how he said he'd feel bad sometimes texting her outside of work hours because, he knew she would respond. And how he had texted her about a work matter at 6:58 on April 24th of 2018, and was never read. Never got a response all day. This is from a person who responsiveness was her mantra. It was her thing. Never heard back. Same thing from Matthew Herbert. Incredibly prompt, responsive. He texted her work-related item on the 24th. Never heard back. Elena Pathick, you heard from yesterday, neighbor and friend of the victim. She told you how she spent time with the defendant and Shanti, and that in all the time that she spent with them, there was no affection, no touching, no hand-holding, no kissing, not what you would expect of a couple that's the most in love they've ever been, as the defendant said in his interview at one point. No affection whatsoever. During the whole time that she knew them, she never knew the defendant to work. Meanwhile, Shanti's working all the time. She went to the house several times. She works in interior design and home renovation herself, like nothing she'd ever seen. House completely destroyed, taking an inordinate amount of time. She said, she would expect it to be able to be completed in 3 or 4 months. They'd been living in this unlivable house for a year and a half at least. She told you how Shanti reached out to her, frustrated with the progress of the home. I'd called her for help and guidance. And then she also told you, as some of the other witnesses said earlier, that hadn't had as recent a contact, that Shanti was excited or eager to be on the Zombie House Flipping show. We heard that from Keith Orey from his earlier encounter with Shanti. But you actually heard from Ms. Pathick that close to the time, she didn't know about it. She wanted the house to be complete. So this was still an ongoing tension that she knew of at the time. You heard from Samantha Adams, a personal assistant to Shanti, up until about a week before her murder. You heard that she spent a good deal of time around Shanti. She worked with her, about 20, 21 hours a week, and that of that time, she was actually, next to her or around her, more than half of that in the same small room, helping with Jackson. She said, she observed how Shanti would work, how when she would work, she would wear sort of business casual clothing, even though she was working from home. She would put on jeans, a blouse. She would never wear just pajamas or sort of loungewear when she was working, except for a brief period of time right after the appendix surgery that had passed. And she told you that at the time of her murder, even before she left her employ, that she had gone back to wearing the business casual type clothing, jeans, a blouse, not shorts or a tank top, and that would be very unusual for her to be wearing on a work day. You heard that she, was always on the phone, was very diligent with her work, again with Samantha Adams. And you heard from Samantha Adams that she, on occasion, would observe the defendant and Shanti argue and bicker, sometimes about issues related to the home. You also heard from Samantha Adams about the engagement ring. And she's somebody that saw her multiple times every week for 16 months, at least 3 days a week, several hours a day. She was around her, and she always knew her to wear her engagement ring and her wedding band. And the only time that she ever didn't wear even her wedding band was for a brief day that she took it to have it go fixed, to have a diamond replaced. And then as soon as it was replaced, she went back to wearing it all the time again. Defense asked in their cross-examination of her that, do you think she even wore it when you went to a water park? And she said, yeah, I mean, I'm not sure, but I think she did wear it even at the water park. She doesn't remember any time in the 16 months that she was around Shanti that she did not wear that engagement ring after they became engaged. You heard from Sean Johnson, the DNA expert in this case. You heard about Shanti's blood being found on the sheets, Shanti's blood being found on the carpet, on the bed rails. You saw the defendant's DNA, although in a lower quantifiable level, found on the bed rails, compatible with someone cleaning blood off the bed rails. You heard about Jackson Cooper's blood being found on the sheets that were recovered after being taken by the private investigator. But a big takeaway from the DNA expert is, of all the DNA that was interpretable in this case, all the different spots that were looked at, every piece of that DNA was from either Shanti, Jackson, who lived in the home, or the defendant. Nobody else. No mystery person, just the people that lived in the home. Also of note from the DNA person, Mr. Johnson, is that there was a statement by the defendant when he was interviewed by law enforcement about them having intercourse over the weekend on Saturday and Sunday. And the general rule, Mr. Johnson said, and obviously this isn't the end-all be-all, but the general rule is that male DNA after sex would be found 5 days after an event. Well, a vaginal swab was done in this case 3 days after what the defendant says they had sex. No male DNA found. You heard from the medical examiner, Dr. Utz. He told you how he did the autopsy in this case on the day after Shanti was found, the morning after, at 9 a.m. He said the cause of death was blunt force trauma and strangulation, and the manner of death was a homicide. Not an accident, not undetermined, but a homicide. You heard the litany of injuries that Shanti suffered. 2 skull fractures, hemorrhage in the head, a broken hyoid bone, and other cartilage in the neck, both sides of the throat, hemorrhage of the tongue, hemorrhage of the strap muscles, abrasions and scrapes all over her body, her shoulder, hand, chest, contusions all over her body, consistent with being grabbed, and also, importantly, consistent with being grabbed while she was alive. Injuries to both eyes and, both sides of the mouth, the chin, the jaws, across the throat, and the injuries to the eyes. So he talked about the petechiae that you see, the small burst blood vessels that you can see in the face and the eyes when someone is strangled to death. But in Shanti's case, her eyeball was essentially burst inside itself. And you saw those photographs. You saw the pressure that had to have been used to cause that in the eye. You saw her ear. You saw her ear that looked like, and as Dr. Utz testified, looked like if it had been pulled even a little bit more, it could have completely come off the head. This isn't an injury consistent with a fall. you heard from Dr. Utz, the totality of the injuries, even aside from the strangulation, was completely inconsistent with a fall. In the totality, yes. Could somebody fall and bust their cheek? Sure. Could somebody fall and get a black eye or bust their head? Yes. But could somebody fall and hit both sides of their eyes, both sides of their mouth, under their chin, on their arm? Even if Shanti had been at the top of a tall staircase and fallen down, those type of injuries wouldn't be expected. And that's not even taking into account the obvious strangulation that is not consistent with any kind of fall. Finally, yesterday you heard from Detective Sprague, and she told you about her investigation. She told you how she went to the Tronnes home 3 different times with warrants. She canvassed and interviewed witnesses. She noticed the sheets that she expected to have blood on them that were missing, that she was ultimately able to find, that an investigator had about a year later. And those sheets had blood on them, as she expected they would. She found in the nightstand empty ring boxes. But she, at that point, was looking for a ring. She opened those ring boxes, as she told you, and there was no ring in the ring boxes. And then, of course, you heard the lengthy interview of the defendant, which obviously he went through a number of points, his version of events that just, as I said previously, don't make sense. So I want to talk specifically about the parts of the interview that don't make any sense. So the issue of ownership of the house, right? So in the interview, the defendant's asked him, before they got married, the defendant bought this house cash for about $600,000. And he bought that house into a trust that Shanti wasn't on. So she had no ownership interest in this house that she was living in. And his story, his version of why, after they'd been married for over a year, and he hadn't been able to somehow get the paperwork together to put her on this house, didn't make any sense. It's nonsense, doublespeak. And he hadn't put her on this house or turned in the paperwork. He says at one point in the interview, well, to them it was done. Well, to the law it wasn't, and to her it wasn't. At the time of her death, even at the time of her death, she had no interest in this home because he hadn't done the paperwork to do it. And I ask you, if you're going to have the evidence back there with you, you're going to be able to listen to that portion of his statement. And I noted it. It's around the 4-hour and 23-minute mark, at about 50 seconds, that he talks about this nonsense doublespeak about how he just wasn't able in 14 months of marriage to get her on this house. It doesn't make sense. Another thing in the defendant's interview that doesn't make any sense is the whole discussion about sex the weekend before Shanti's death. First of all, the way he discussed the sex itself was bizarre. He discussed it as almost a person that was detached from it. It was a person that was not involved himself. A quote was, when asked by Detective Sprague about the sex, she got what she needed. That's a strange way to talk about, something like that with someone you're the most in love with that you've ever been in your life, as he says. She got what she needed, like it was some sort of service or good that he was performing. Also strange in that sort of same conversation was this discussion of Shanti's menstruation. He brought up the blood and the menstruation as, before anything was talked about as far as blood on the sheets or anything like that, in anticipation of needing an explanation for why this blood was everywhere, right? Before asked anything about that or, asked anything regarding that by Detective Sprague, what does he say? Well, she was, menstruating and it got everywhere. It was a mess. We usually put a towel down, but conveniently, on this time, no towel was put down. and it was immense. It got everywhere. That's strange. The discussion of laundering the sheets, but not the bed cover, and not doing that until Monday, and then leaving the blood, the bed cover covered in this menstrual blood up until the time she's discovered murdered. That doesn't make any sense. And the reason that the bed cover was placed under Shanti by the defendant, because no other reason makes sense, is because there needed to be a reason for the amount of blood that was on that bed cover that she was placed on. Because otherwise, how did all that blood get there? Because it's not going to be covered by the menstruation. So of course he took her body and put it on that bed cover. So the morning of April 24th of 2018, Tuesday morning, Shanti, a workaholic, leisurely comes down first a little after 7, goes back upstairs. Apparently at this point, this is according to the defendant's version of events, she comes down, they have a brief chat, she goes back upstairs, I guess in her pajamas or shorts or tank top, never looks at her phone, never picks up her phone, she's just not looking at it that day. Goes back up, then a couple hours later, she comes back down around 9:15, still in her leisure clothes, still never having looked at the text message from Mr. Connolly that morning. And she says, even though I was in, a lot of pain because I broke my tooth yesterday and I made an emergency dental appointment, I'm thinking about not going to that. And she goes back upstairs, all the while, never checking her phone, never responding or sending any text messages related to work, although that's, what she did. Then, after that, not thinking anything of it, the defendant, according to his story, he walks the dogs. That's about 15 minutes. He cleans the pool. He does some work around the yard. And then, not 2 hours after first walking the dogs for 15 minutes, he then decides, I'm going to now go to this park, and I'm going to take the dog there for 2 hours in the middle of the day. I'm not going to bring my phone, not going to send any text, doesn't receive any text this whole time. He's going to go to the park for 2 hours in the middle of the day, not say anything to Shanti about it. Didn't think he needed to. He doesn't get back from the first walk of the dogs and say, hey, did you go to your dental? I guess you didn't go to your dental appointment. Doesn't text her about that, even though knowing she had made this emergency dental appointment. No communication is that, just leaving her alone. So then he gets back about 2 p.m. after leaving at 11:45. And then of course he gets back, doesn't check about the tooth or anything like that. He then, cleans the pool again because, the pool can get, I guess, pretty dirty in a couple hours that you've been gone with the dogs to the park. So he does that. He, messes around at the house. And then around 3 o'clock or so, he finally decides to go up and see who's getting Jackson. And that's when he finds Shanti in the tub. Now, you heard his story of how he found her. He hears the water sort of trickling. He calls out, doesn't hear anything, goes up there, and then he finds her. And then the hysterics. I would say the waterworks, but as the detectives told you, there were no actual tears from the defendant. But then the hysterics of how he found her. And you heard his statement, and obviously it's in evidence. It starts around the 5-hour and 30-minute mark, and you can go back and listen to it again. But listen to his speech and how he speaks around that time as compared to how he's speaking, freely and comfortably about the home renovation or other things in the interview. It's halting. It's staccato. He fades in and out. He drifts off mid-sentence. Or he drifts off mid-thought. It's not like he was describing things just before. He's making it up as he goes along, and it shows. he's asked by Detective Sprague, about her and, about his statement that they've never been more in love than after that weekend. And he's asked, what do you mean by that? Like, you've never been more in love. Like, what about this weekend? Why would you say that? And he doesn't talk anything at all about Shanti or their relationship or what's great about her or what he loves about her. And you can hear that on the interview. What he talks about is, well, they're just such a good place with the home project. They're where they need to be. They're finally about to be on the show. Things were lining up. So he's never been more in love. When asked about that, there's nothing about Shanti that caused him to be in love. It's just more discussion about the house. Now, also in his own interview, the defendant's asked about the engagement ring, and he says that she always wears the wedding ring. The ring should be on her body. Now, that discussion happens about the 7-hour and 4-minute mark. So I want to talk about the issues that the evidence shows existed in the relationship between the defendant and Shanti. You heard several of the witnesses that we talked about said how they would argue and bicker over the home. Okay, couples argue and bicker about things, but this was an ongoing trend with them. And oftentimes when couples argue and bicker, one of them doesn't end up brutally murdered. You heard from Keith Ory about the obvious tension the week before that we discussed. You heard about the sleeping arrangement. You heard how the defendant was sleeping in the garage with the dogs while Shanti was staying in the essential, one-bedroom apartment, separate and apart from him. And this had been going on, for over a year. And that they were sleeping apart most of the time, even when Jackson wasn't there, which was, a good bit of the time, because he spent time with his biological father. So they're not sleeping in the same room. They're not sleeping in the same wing of the house. They've been married for just over a year. That is unusual. You heard how the defendant hadn't worked since he came down to Florida, 5 years before this. And he told you in the interview, or told the detective in the interview, that he came down with about $800,000 or $900,000, not an unsubstantial amount, to come down to the bank account that he'd saved through his career. And he'd come down with that amount, and then he spent about $600,000 on a house, on this house. So that leaves $200,000 to $300,000. Now, it's again not nothing, but there's no other income coming in from him. So he's got $200,000 or $300,000 in the bank, but all the money coming into the couple, to the family at this point, is from Shanti, who's working nearly around the clock. You don't think that causes some tension? She's living in a one-bedroom apartment, and she's sharing a room not with her husband, but with her son in a bunk bed in the room. There's no kitchen. They're heating things up in a microwave, a toaster oven, and this goes on for over a year. You think that doesn't cause some tension, some issues? All of this for a house that she has no ownership in, that in the 14 months that they were married, the defendant couldn't get around to getting the paperwork for her to be on the trust and have an ownership interest in the house. So what did the defendant stand to gain? And we're not here to necessarily say that this was just a financial case. This is a totality of everything case. But what did the defendant stand to gain? Well, there was over $800,000 in either accounts that he shared with Shanti or she controlled alone that he wasn't going to have to share anymore. There was the $350,000 life insurance policy that he stood to get as a death benefit from her death. And I would also note that in the interview, even though it had been just over a year or so before, since he sat down in the office with Patrick McCarty to make that change, and he told the detective he thought it was $250,000. It was $350,000, a little bit of minimization. He also stood to gain the continued ownership of the home without ever having to put Shanti on the trust. and he would have a complete say in what to do with the house and well over $1 million to do with it as he wants. So I want to talk now just about the facts around the murder itself and how they all point to just the defendant. Okay, so this, let's think about this day, April 24th of 2018. This is a Tuesday. It's the middle of the day. By the defendant's story, the murder would have had to happen sometime between 9:20 a.m. and 3 p.m. Realistically, based on his story, it would probably have to happen sometime after the second time he left with the dogs, around 11:45, because 15 minutes just isn't a lot of time to leave a stranger to slip into the house, to violently beat Shanti, to strangle her, to leave her partly submerged in a tub, and then to go down the stairs or somehow sneak out undetected, not leaving a fingerprint, not leaving any DNA. 15 minutes is probably not a lot of time to do that. Of course, it doesn't make any sense at all that some mystery intruder broke in and did this anyway. Why? Again, the middle of the day, the house is under a house that's under extreme construction. The upstairs where this happened, only accessible by stairway, one stairway. And what's left in this house? Several phones, a computer, valuable electronics, cash, no signs of sexual assault. Just some random person in the middle of the day? That makes absolutely no sense. And one thing as jurors you're not supposed to do is go into that jury room and check your common sense at the door. That's something that you bring with you. And that this could be some random stranger that left no trace and took nothing, that makes no sense. What does make sense is that the defendant did this. This was a murder of rage, of anger, of extreme violence. This isn't an intruder breaking in, stumbling onto a person in the middle of the day that they don't expect to be there, shooting them once, stabbing them, picking something up and hitting them with the head, and then running out. That's not what happened here. That's not what the evidence shows happened here. This was an intentional killing. It may not have been planned, or it may not have been planned for long, but it was absolutely intentional. A premeditated design and intention was clearly formed at the time of death. She wasn't hit and injured in just one place. She wasn't just hit in the head. She wasn't just hit in the eye. She wasn't just hit in the jaw. Wasn't just hit in the eye on the other side, scraped on her arms. It was everything. Her ear was almost ripped off. She had bruises and abrasions all over her body. And then there was the strangulation on top of that. A random stranger that comes into a house isn't going to, take the time that it takes to strangle a person, to move them to a tub. Not take anything? Doesn't make any sense. Leave no sign behind, no fingerprints, no DNA? That doesn't make any sense. You heard from Dr. Utz that there was a study done a while back around World War II about how long it takes to strangle a person. A cuff was placed around soldiers that volunteered for the study. And he said it actually took less than you would think, 10 to 12 seconds for them to lose consciousness. Now, obviously, these are live people. They didn't kill them. So it was, 10 to 12 seconds, even under perfect circumstances, with a perfect cuff around their neck, to lose consciousness. So even if you take that 10 to 12 seconds, which would be in a perfect sort of lab setting that it would take to strangle someone to the point of losing consciousness, that is intent to kill them. That 10 to 12 seconds, if when you first put your hands around someone's neck and start squeezing, you don't intend to kill them, by 10 seconds, the defendant absolutely had. This was personal. Now, I talked earlier about the version of events for the defendant, but we know, of course, that the defendant's version of events isn't true. We know that Shanti was dead at 6:58 a.m. when that text came in from Dan Connolly, or very closely there in time. She never responded to the text, and she never responded to any other call or text in her life. We know how responsive she was. It was a bedrock principle of hers to be responsive. In addition to the calls and text, she didn't take any steps, as we talked about. She didn't go down a staircase. She was in her pajamas. She no-called, no-showed an emergency dentist appointment at 10. And the reason she no-called and no-showed that dentist appointment is because the defendant had already murdered her at that time. We know at 11:50 the defendant wasn't walking the dogs like he said he was. And we know that because of witness testimony. They saw him. Different clothes from when he encountered law enforcement, no dogs. And again, this 911 call, the beginning of the show that the defendant put on to try to get away with this murder. What sticks out to me a lot about that call is, well, first of all, obviously the feigned hysterics, but the CPR. Think about this. And multiple witnesses talked about the rigor mortis. And you see in the picture her hand is in the air, and how rigor mortis works, and how that would appear to him. And yet he gets on this call with 911 and acts like he's performing CPR. You can even hear him breathing hard, like he's doing CPR. He's not a dumb person. He made a small fortune for himself before moving to Florida. And that person is going to think that this obviously dead, lifeless person whose body is frozen, he's going to perform CPR on that person? That's unreasonable. It's the state's burden in this case to prove beyond a reasonable doubt that the defendant is guilty of the crime of first-degree murder. Not beyond all doubt. And that she could have somehow fallen, or that some random intruder that left no sign came and did this, that's not a reasonable doubt. That's a imaginary, speculative, or forced doubt. And those doubts are not reasonable. And the judge will instruct you on that. So I want to talk about the law. You're going to get the jury instruction, so you'll have all of this with you. But the judge is going to define for you what first-degree murder is. And along with first-degree murder, there's some lesser-included offenses. There's second-degree murder, and there's manslaughter. Now, the defendant, we've certainly proved beyond a reasonable doubt, is guilty of manslaughter and is guilty of second-degree murder. But you should not find him guilty of manslaughter or second-degree murder, because as the judge will instruct you, you're to convict to the highest crime charged that's proven beyond a reasonable doubt. So just to go over the elements of manslaughter you have to prove. Essentially, to prove manslaughter, we have to prove that the victim is dead and that he intentionally committed an act that caused the death. Most notably, you won't find anywhere on this instruction that he intended to kill the victim, or that he even acted with any kind of particular mindset, like a depraved mind, which is required for second-degree murder. We just have to prove that the victim is dead and he committed an intentional act that caused the death. Well, we've certainly proved that. He beat her to death. He strangled her. He tried to cover it up. We've certainly proven that, but we've proven more than that. Second-degree murder, which is another lesser-included offense in this case, requires that we prove a little bit more as far as mindset than manslaughter. In addition to proving that the victim is dead, which was stipulated, the judge read a stipulation, obviously, that the person who died is Shanti Cooper-Tronnes. It was caused by the criminal act of David Tronnes. Again, that criminal act, as we've talked about, is the beating to death and the strangling of her, and that the unlawful killing was eminently dangerous and demonstrated a depraved mind without regard to human life. Well, hitting someone the amount of times that the evidence shows that Shanti was hit and strangling that person, that certainly shows a depraved mind, and it certainly shows that kind of activity is eminently dangerous. But one thing that second-degree murder doesn't require is we don't have to prove an intent to cause death for second-degree murder. But the facts in this case go beyond that. So while we've definitely proven second-degree murder, this defendant did intend to cause death. And that's why second-degree murder isn't the appropriate verdict either. The only appropriate verdict in this case is guilty as charged of first-degree premeditated murder. And to prove this, we have to prove that the victim is dead, that the death was caused by the criminal act of the defendant, and that there was a premeditated killing. And this is important. So premeditated, what does that mean? Well, that's defined for you. It's the act of killing after consciously deciding to do so. The law doesn't set a fixed amount of time that has to be. It could be from when he first, it could well be that from when he first struck Shanti Cooper-Tronnes in the head, broke her skull, maybe at that moment, if that's the only injury in this case, maybe that's not first-degree murder. But he didn't stop there. You have the severe beating of Shanti. You have the injuries to both sides of her face. You have the fractured skull, the swollen shut eye, the damaged eye on the other side. That you saw the intense bruising and bleeding in both sides of her mouth. This was a beating. So at some point in that beating, the defendant, and you can infer this from the facts, intended to cause the death. But this isn't just a case of a beating. This is a case of a strangulation as well. And if the defendant, even throughout the beating, you don't believe necessarily intended to kill Shanti, that he was, he had a depraved mind perhaps, but maybe he didn't necessarily intend to kill. When he's holding his hands or his arms around her, squeezing the life out of her for at least 10 to 12 seconds before loss of consciousness, and we know, based on this circumstance, for a lot longer, he certainly had the intent to kill. That is a premeditated design. That's first-degree murder. And that's what this defendant's guilty of. The totality of the evidence in this case points to only one person, the defendant as he sits before you. The defendant is responsible for all of the injuries that the victim suffered in this case. The totality of the evidence shows that nothing else makes any sense. He did it with a premeditated design. He even took the ring with him. We ask that you convict him of first-degree murder. Thank you.
Thank you, State. We're going to take a brief recess. During this recess, you might want to, if you have some snacks back there, we'll probably go a little bit later before we start our lunch today. And also, I do anticipate you getting the case today. So if you need to make any arrangements obviously, I think I mentioned this at jury selection. Once you receive the case, obviously I don't have control over how long you're here, so you might want to make any arrangements you need to for home this evening if you have any plans. And with that, we'll be in recess for 10 minutes till 11:30, and you can follow the deputy out. bring the jury back out. Ready, defense?
Sure.
Okay, we can bring the jury out.
Sounds great.
Defense, you may proceed.
Thank you, Your Honor. This court.
You may proceed.
Good morning, ladies and gentlemen. On behalf of Mrs. Jacks and David Cooper-Tronnes, Richard Zaleski, and I want to thank you very much for your careful attention up to this point. It's been evident that since the jury selection process going back to last Wednesday that you all have given the trial the attention that it deserves. You carefully participated in the jury selection process, allowing us to pry somewhat into your thoughts and beliefs in your lives in order to be able to qualify you as jurors for this case. And you're qualified for jurors in this case because you agreed to hold some basic principles in the criminal justice system to be true. And we started off early on in the process by talking about the presumption of innocence. And a defendant, as they say in the trial, at the beginning of the trial, is cloaked in a shroud of innocence, just like anybody else in the room. They stand accused by the government, but they are innocent until proven guilty, right? And we talked about the burden of proof sits over here with the government. We talked about the fact that this is not a civil trial. We're not talking about a preponderance of the evidence. This is not a 51-49 tip the scales and the government wins the day. Their burden is a very high burden. It's beyond the exclusion of every reasonable doubt. The definition we'll go over in just a little bit, but when you talk about the fact that the burden of proof is beyond exclusion of every reasonable doubt, it isn't to the title of the charge. It goes to the elements of each offense, and those are broken down for you in the law the judge can give you. But each element of the offense has to be proven beyond the exclusion of every reasonable doubt in order for you to sustain a guilty plea. And we'll go over the elements, but if they fall short on one element, the whole thing fails. That's how it works. Proof beyond a reasonable doubt, you have to check all of the boxes. And when we're talking about this case, the box that's in question, we talk about, forget about that Shanti Cooper, we stipulate her identity, we got photographs, there's plenty of evidence that Shanti Cooper is dead. I think there's ample evidence, to suggest that this was a violent encounter, whether it was a violent fall or a violent attack. There's no direct evidence as to what happened in the apartment that day. This is a circumstantial case. So the third principle that we talked about in a criminal trial, and you all pledged to adopt it, even if it wasn't natural to normal life or everyday life was the fact that two sides to every story and all that kind of stuff is left at the door. That a defendant has the absolute right to remain silent. It begins at arrest with Miranda. You all have heard it on the TV shows over the course of the year. And you come to learn that it continues through the course of the trial. Up until the point that the case is over. Having pled not guilty, the burden still sits here with the government. And unless they have been determined to have proven the elements beyond a reasonable doubt, the verdict has to be not guilty. Just like in jury selection, because you hadn't seen no evidence, if you were asked to come up with a verdict, knowing what you do about the charge, you would have had to have been not guilty. And just like in close of openings, because just like closing arguments, opening statements, are not evidence. And I hope you were taking care from those who looked like you were, because Mr. Smith stood up at the beginning of this trial and he gave you a list of promises. He told you a story. It was very dramatic at times. And he told you, he pledged to you, that through the evidence, the testimony to stand and the exhibits, that he was going to deliver on those promises and prove these things to you. And we'll go through those in just a few. But as we speak, there's almost 100 pieces of evidence back here, hours of an interview. Our memory is not gospel. You are to rely upon your own memories. The judge will tell you that you've got notes, you've got the opportunity to review the evidence and carefully review it and re-review it if you care to make sure you got it right, because there's a lot of information being thrown at you. But maybe you didn't even understand the significance at the time. But that's the point of this process, for us to highlight some of these things for you. And it's also the point of the deliberations, so that you go back into the room and you bring your ideas together collectively to share. This is not follow the leader. You are not sheep. You have a vote, and you should have an individual voice. You pledge that as well. The other thing you pledge is that you would hold the government to their burden. That you're not here to play detective. You're not here to solve a crime. You're here to determine if the government has proven the crime that they have alleged and the elements of that crime. And specifically, that Shanti Cooper-Tronnes was murdered, and David Tronnes is the person that did it. And did they prove beyond a reasonable doubt that he is the person that committed this offense? Submit to you they did not. Beginning of the trial, the state sold you hard a financial motive. Shanti's the only source of the income. She's the breadwinner. He does nothing other than take care of the pool and the dogs. Well, you know through the evidence that promise was broken by the state. They sold hard an unhappy marriage and frustration and tension due to this construction project, the time and the scope of it. So you've got a financial motive, you've got this frustration because of the house renovation, and it's a boiling pot, right? Because they have now been relegated from the main house to this 800 square foot apartment, and it has turned into such a problem that it led to murder. That's what the government would have you to believe. Those were their promises. There were arguments about Shanti not having ownership. There was absolutely no evidence presented to you about that. There was none. Where was the argument about her being added on the ownership? And David's explanation in the course of the interview, go back and listen to it. Because it was a contentious divorce. She did not like James Cooper. She did not like him at all. In fact, she changed the beneficiary on the insurance to David, and she changed, all of it, because she didn't want any money to go to James Cooper. That's what David's explaining to you, that structuring the trust took care, and it was trying to figure it out, because they didn't want to leave everything to Jackson, because they didn't want James having control over it. So we're trying to figure out a way to structure it so that was possible. That was the delay. That was the explanation. They would have you believe that this was an unhappy marriage, that they slept in separate beds, and they slept in separate rooms, in separate buildings, and they lived separate lives. That the marriage was crumbling just a few years in. Well, We know through the witnesses and the testimony that those promises were broken as well. They bickered like a married couple was the testimony, but quickly made up. There was no tension about the house. In fact, you hear through the testimony that the house was turning a corner. By 16 months that they were living in this apartment, there were accommodations made. Why? Because it's a small space. It's 800 square foot. You've got an 8-year-old boy sleeping in a room with 2 adults, one of which is not their biological parent, and one of whom snores like a trucker and is not compliant with her CPAP machine, which we know was extremely bothersome to David Cooper-Tronnes. We know that Jackson and Shanti went to bed really early because Jackson was 8 years old. And we know that David stayed down in the garage on occasion, but not always. They would like you to believe that he was banished to this garage because things were so bad, that he didn't sleep with his wife, he didn't have any relations with her, that this is all nonsense. Well, we know the physical evidence refutes that, right? Because ultimately the sheets that are tested and are supposed to have all of this evidence of this violent, brutal attack on the bed have 2 tiny spots of Shanti's blood. What is most of the blood? A bunch of tiny little spots attributed to David, and half dozen or so attributed to the son Jackson. 2 of dozens of the stains, 2 were attributed to Shanti. These are the sheets that were supposedly on the bed during the course of this attack, and the course of and they should match up the stains with the mattress pad and the carpet below, and the slats and the wooden rail. Where is the evidence? It's pure supposition, ladies and gentlemen. This is a case about a rush to judgment. It's a case about confirmational bias. It's about a sloppy investigation. It's about circumstantial evidence, pure supposition, all steered by Teresa Sprague, who prejudged this case based upon a phone call received from her from an officer at the scene about these crocodile tears. We know she hadn't heard the 911 call, and it's a call, by the way, so to suggest that one's got a mind and to say that these were not real tears being shed on a phone call is pretty special, isn't it? Again, supposition. It's a phone call. Officers show up. They describe him to be, this is Stephen Wilson, described him to be hysterical, in a state of rambling, but insufficient tears. That phone call goes out to Teresa Sprague before she even steps foot on the premises. It goes up into the stairs. She's got an opinion. She's got a belief. And how do we know that? Because before she speaks to David, she walks around the scene, she speaks to Ralph Kalachi, Wilson poisons Sprague, Sprague poisons Kalachi, with this idea that this is a domestic violence attack, because they've got it all figured out within hours of being at the scene. Before any evidence is processed, no DNA, no prints, no nothing. This is just a hunch, ladies and gentlemen. A hunch. Wade Sperry pronounces her dead, doesn't have a real memory as the condition of the body, of the clothes. He wasn't in there that long. But that's all cleared up, and we've got conflicts into the evidence about how these people encountered Shanti's body and how they perceived her hair and her clothing in different states of wetness and dampness and such. It's confusing, isn't it? I mean, the crime scene makes no sense. The state went through the witnesses. These were their witnesses, but it's important that we review much of their testimony because throughout the course of the trial, many of the state's witnesses offered up valuable information to support the defense. We know that CSI Crosby was at the scene, and he was the lead CSI tech. He was working with a young lady in training, CSI Taylor. And so we talk about a sloppy investigation, and this isn't taking pot shots. We've got Teresa Sprague, who's got tunnel vision. She's a domestic violence superstar who comes in, and this is what confirmational bias is. You have a belief, and one has a belief, and then one goes out and looks at everything shaded in the idea that this supports the belief. because of the bias. If you hear horses, if you hear hooves, it's think horses, not zebras sort of thing, because that's the point. You don't get to fit a square peg in a round hole because it's convenient. And that's what happened here. With the rush to judgment, with the confirmational bias, those two detectives went into a room with David Cooper-Tronnes and worked him over. 16 hours at a station he spent. After the slaying of his wife, he shows up at the police department at 5 p.m. on April the 24th. He sits there. What does he do? Voluntarily, by the way, not under arrest, goes down to the station at the request to assist law enforcement with their investigation. Rides with law enforcement, doesn't drive himself, goes to a room. They photograph his body and his clothes, close-up of his clothes. They swab his cheek. They swab his hands. They clip his nails. They ultimately take his clothes. He surrenders and gives it to him. Fine, have him. Put him in a paper gown. Sit him in a cushionless chair. Give him a bottle of water, a cracker. And then what? Let's just sit and wait alone in a room without windows for 4 hours at this point until the detectives come back in and begin their interview sometime after 9 p.m. on April the 24th. They come in with their techniques. Manipulation is what it is. Good cop, bad cop. You know, going at somebody, trying to, get them to warm up to you, trying to trick them. They keep him in the room, talking to him till after midnight. They leave again for a couple of hours. He's again alone in the room. They don't know that he's sleeping. He says he sleeps a little bit. Go back and watch the video for yourself. Go through it. You got an unredacted version, because that's the good news. Mr. J was just fast forwarding through the majority of the gaps. Those long gaps and not the redactions are still there for you to look at. You can go back through and see exactly what David was doing. The sobbing at times, the crying at times, how often his head was down. How many hours? 16 hours he sat in that room. We had the 3.5 hours, you watched it all, the 3.5 hours to begin with, and then the second portion, right? They come back in sometime after 2 o'clock, and they speak to him until almost 5 a.m. You didn't watch all that because some of it was considered irrelevant for the purposes of the state's presentation, but it's available to you. Go back and look at it. Look at how these detectives treated him for that last hour and a half. Look at it. Because it's important, and we'll go over the law as to why it's important. They left him in the room. Come back in at 2:20, speak to him at 5 a.m. At this point, it's a lot more aggressive, isn't it, the second half? They come in, the good cop sits aside, Detective McClellan, Sharp, comes in, takes her seat. We know she's in training too. This is her first real homicide that she's been on. And with all due respect, it kind of showed from the stand a little bit. I mean, when Detective Sharp testified, she didn't really have an accurate memory. A lot of it was, I don't recall, this, that. She didn't have anywhere near the memory that Detective Sprague did. It seemed that she was relying upon her and shadowing her throughout the course of investigation. And maybe that's why some of the mistakes were made, right? Maybe, because this is the sloppy investigation. We've got a CSI tech in training in Taylor. We've got Sharp and McClellan in training. And the other two are running through just trying to make sense of this crime scene, 800 square feet. You want to talk about the mistakes and the sloppiness? How about the sheets? Mr. Cooper-Tronnes is sitting in a room, talking to them. They take note. They find it's very odd that he mentions blood on the bed, sex during menstruation, and the idea that They might be finding some blood, and he wants to be able to tell them that so they can look for it and rule it out as anything significant. The detectives go to the scene, right? They look, they make note of the bed. It looks like it's been made in haste, and it's clean sheets, but it's not made right. The blanket's on one side, this and that. So we've got David's mention of the bed. We've got the detectives noticing the bed. We've got Detective Sprague. She comes to the scene, and through seeing a single diamond stud earring on the nightstand next to the bed, she's come to figure out the whole sequence of events, how this attack has happened, right? She testifies that her theory is that the attack happened 11 o'clock at night, the night before. She's taken off her earring to go to bed. She got one out. She got her head turned. She doesn't see the attacker coming, and this is how it happens. This violent bludgeoning on a bed with no scientific evidence of it. You want to talk about some droplets of blood that belong to David Tronnes, some droplets of blood that belong to Jackson Cooper, and a couple of small dots that belong to Shanti, and we're supposed to believe her that this is how it happened? It's not supported by the evidence. Again, it's pure supposition. That is not evidence. It's, again, a hunch. Beyond that, they notice some slats that have fallen off the bed that are underneath the bed. There's no other blood underneath the bed, despite the suggestion and the pictures yesterday from an angle that was somewhat distorted to show, where this cutout was versus where the bed rail was. Let's make it clear here. When you're looking. So, just to give perspective, recall how detectives, CSI first encountered her to photograph Shanti on the mattress pad adjacent to the bed. You can see the location of the mattress pad, how it's removed from the bed. You can see where the pad is located with respect to the bed railings. Moving that, see the location of the stains, right? So if blood is running down the mattress, if blood is running down the headboard, if blood is running down the inside of that wooden rail and into the metal rail and onto the slats, one would expect blood on the carpet below it, that amount of blood. It's not there. It's not there because that's not how it happened, and the scientists tell you that they can't determine when that blood was deposited there. And on top of that, that blood had a mixture of Shanti and David's blood, which is supportive of period sex. Ultimately, this is the perspective I'd like you to look at, because those are the cutouts that they took, and they're not under the bed. That's what I'd like you to understand. CSI Crosby testified that he located and photographed a soaking wet or a wet towel with blood on it underneath the mattress pad. We'll talk about how the carpet is wet and the clothes are wet and how did it get wet and it's diluted or that from somebody trying to wash the carpet. Well, we've got an explanation from David that when pulling Shanti out and trying to care to her, that she's wet, she's cold, he puts her on a towel, she's bleeding, so he retrieves a bright colored towel to wipe blood from her while he's waiting for paramedics and 911. They cry nonsense But the towel is there, and it's got her blood, consistent with being cared to, and the towel is wet. CSI Crosby testified and contradicted Detective Sprague, but when he was there and he encountered the locks were unlocked, both doors were unlocked, and he documented that the door downstairs was unlocked, the top lock to the deck was unlocked. Check your notes, rely upon your memory of the testimony, and see that he was there before Detective Sprague. On the 24th of April, sloppy investigation, they come to a home where the main home is a construction site. And you'll see some of the photographs and you'll look at a video. You can see what the state of the home was. At the very least, on the video we'll watch on April the 18th in just a second. If we can cue that up. So, thank you. But the point is, they didn't look at it. They didn't consider it. Detectives show up at a murder, suspected murder, on the 24th, and they don't survey the main home. No fingerprints, no looking for forced entry, no DNA. They don't go inside the premises. They don't look for weapons. They don't pay attention to the fact that there's a ladder leading up to a latch, which allows one to walk, because you heard from Samantha Adams, that there's access to the rooftop deck from the main house. So with the multiple points of access, they completely disregarded one. Why? Why? They walked around, they talked about they searched the landscaping, they searched the dumpsters, they look, around the property, they look on the roof. They don't find a weapon, they don't find bloody clothes, they don't find cleaning supplies, no bloody rags, no nothing that looks like that there's been a scene cleaned up. That's it. Go ahead and take a look at the state of the home on April 8th.
If you want it bigger, you're going to have to shut off the overhead.
Yes, sir.
Hi, family. What's that?
My dad inside.
Oh.
My dad can tell me on his new job.
Okay. I don't know.
Love you, Dad.
Love you so much for that.
Jonesy, I'm your baby. Love you, boy. Mom.
Love you guys so much.
Are you recording me?
Yes. What would you like to say? You have it.
Have a good day, guys. And I will record you.
Love you. Oh, that's right. Have a good night, friend, okay? Guarantee we'll talk to everybody we need to talk to. We'll do whatever we can do, okay? Like we always do. Okay, Dolly, come on, boo. Come on, baby girl. That's a girl. That's my girl. That a girl, sweetheart. Okay, you guys ready? There we go. Good boy, Charlie. Just gonna go, let's see, what we're gonna say. We're gonna go out here where Jackson is waiting for Jim. I'm gonna take a quick look at the Picadine. I think we may have had more frost damage than we knew. practice. Yeah, there's some near fronts, maybe. Oh, there is a near front in the middle. This is really slow coming out. You can see it right at the top. There it is. I thought we lost you, Pickering. And there's the bougainvillea, which is all blooming. Hey, Jim. Hey, Jim. All right. And here's the breezeway. Here is the house with the center supports and the first set of trusses up. And that's the stairway opening. That was the wine cellar. Okay, and two doors on this side, one goes to the garage, and the other one goes upstairs, and that's basically the apartment, which I guess I can actually go all the way up here and show you. You come up the stairs, got 3 windows on the side. And then it's just a full open, it's about 800 square feet at the top of the stairs. And there's a full bath as well, back in the corner. And we just let in a lot of light. Also a lot of heat, of course. And then we've got the door here that goes to the rooftop deck, which is above the family room. So, all right, I think we got it all. And here's Charlie and Molly. Nice sweethearts. Good boy, good girl. That a boy, that a girl. Charlie has his frisbee, and Dolly is looking for hers. Love you guys. See you soon.
Ladies and gentlemen, you can see from that video that April of 2018 was a happy time in the Tronnes household. You can see the beautiful home, the beautiful property. You can see the loving interaction with Jackson and David. And you can see the state of the home, can't you? Through the windows, you can see that there's been significant progress. This is no longer an empty shell. You can see, and we know through the testimony, because this is April 18th, right around the time when Keith Ory's looking for the meeting with the Tronneses, that they're going on this TV show, Zombie House Flipping. Things are about to take a turn for the better, for sure. While there have been hiccups throughout the process, Mr. Tronnes, David's acting as his own contractor, clearly got in over his head to the extent of the demolition taking the time that it did and the changing in contractors. We know that there were problems before Keith Ory came on as a consultant. Keith Ory comes on as a consultant, and he's working for several months up to the point where he decides now the condition of the property is worthy of the TV show. But the TV show's a house flipping program. If you've watched the show before, I think the basic model up until the point of the Tronnes home was that the individuals that are on the show owned the properties, they purchased them for a price, and that they would renovate them, fix them up, and flip them, and they would calculate what your profit is. That wasn't the plan. This was a prototype. This was a new show. This was Zombie House renovations, because it was a home in zombie-like condition, if that makes any sense. But the point is that he thought it was interesting enough for the show and signs them up. They'll get on top of professional care and a production schedule that's clearly going to speed the process up. They're going to be getting Keith Ory and his band of contractors that are renowned locally. They do historic home redevelopments. They have won awards for the homes specifically in Delaney Park. David got a referral through one of the neighbors, and now he had the man to do the job. So on top of the $30,000 in perks or so, it seems that with a May 7th production beginning, that the Tronneses were due to be in a finished home sometime by Labor Day. Where are the dire straits? Where's the tension? Because Keith Ory came over and said that she, what, was annoyed? Well, what was she annoyed at? Was she annoyed at work? Life on life's terms? Was she annoyed with David? Or was she annoyed with Keith because Keith was giving him a hard time about a fee dispute, even though that he wanted the show? He's like double dipping. He's going to get the show. He's going to get his consultant fee, but now we got to put the project on hold for a couple months. And it was voluntary, and it was worth it. They agreed to it. They wanted the timeout because they wanted this man to take the project over and run it to the finish line. And what did Keith say? They had the means to do it. So all this financial motive, it's hooey. It is. The man bought a house for $600,000 cash. He came down with money. The financial accountant, the financial expert testified, and you can look at his notes. They entered this into evidence. Talk about what Adam Frank testified to, because he certainly didn't get up there and suggest that there was malfeasance or any criminal activity in his forensic accounting work, right? He was given a bunch of bank accounts. He was asked to just review them and come up with the totals and work on a timeline. And you can see, it's pretty clear, David was a man of means before he met Shanti and before he married her. He bought the home before he was married, and when they got together, he deposited and transferred a substantial amount of money into their joint accounts. $284,000 wire, a $100,000 transfer from the trust, a $200,000 deposit at the branch. We've got essentially $584,000 of his money over and above the money that he paid for the house into the joint accounts, over and above the $130,000 in his sole account, over and above the $120,000 in his retirement account, not counting the AXA accounts for his life insurance. Where's the financial incentive? Her $380,000 or a few $100,000 policy? Or not having to share the house with her? What about a divorce? A divorce would accomplish that. Murder to get the house that he bought before he married her because she contributed to renovations? Well, he paid $600,000 for a house, and she lived there essentially rent-free, note-free for all that time, so wasn't there a benefit there? Who's the freeloader? They want to paint him as he's sucking off her, like, all of her money, that all he does is play with the dogs, play with the plants, and exercise and swim in the pool, right? And serve iced tea to her meetings. He's a do-boy, is the picture that they paint for you, that he hasn't worked a real job. Well, he's a man of investments. He invested in a property, and he took on the job of general contractor. And that's been his job, ladies and gentlemen. That's been his job. And why all the downtime? Well, because of the delay in production. Now he's got a couple of months. You can see from the video, by the way, I mean, talk about the narrating. He's very proud of the property. I mean, he's proud. He's proud of his family. You can see loving interaction. This is a good day. It's a good time for the Tronneses. That's what that video shows you. Sheets piled up on a banister? That's what the government's taking from it? How the bed is made? Well, what that proves to you is those sheets were purchased beforehand, and they existed before the day, so they certainly weren't brought in as part of some cover-up. The bed was made in haste. Shanti was sleeping in it alone on that side of the bed. The blanket was on her side of the bed. Why is that unusual? And if it was so unusual, why didn't you take the darn sheets? Detective Sprague will tell you because she wasn't running the show. She wasn't in charge. The lead detective, deflecting and defensive is long. I mean, we'll talk about weighing the evidence and how people respond to questions and stuff. For the most part, this was pretty clean, right? Throughout the course of the trial, witnesses got up there and with a little bit of hindsight and trying to throw some significance onto some things that were otherwise insignificant, they were straight shooters. Not Teresa Sprague. With all due respect, it was like watching a political debate where it didn't matter what the question was. Someone was going to say the answer they wanted to say. So Shanti had $387,000 in her own account, and that's the motive for this murder? To get rid of her so he can have the house alone? That video shows this was their dream home. This was their forever home. They wanted this. They wanted it for the school district. They wanted it for the family. That was what they were doing. This wasn't all about fleecing a woman to slay her, to take her cash. And if their motive makes no sense, and if you go back to it and if you really look at it and you take all of the evidence, because they've done a lot to prove up this potential homicide, while the medical examiner says that it is possible that a violent fall, like the magic bullet, right? I mean, it would have to be the perfect fall for somebody to hit the shower in a manner and catch something on the way down, injure the knee, hit a spigot, but falling when you're not supporting yourself in dead weight and landing directly on the ledge, if you were to crush something in the way of the throat, like a karate chop, and then laying prone over the edge of the tub with the head down over the edge onto the bottom of the tub. We heard about positional asphyxiation. He couldn't rule that out. He couldn't rule it out. He just said he didn't think it was consistent. But he also said he couldn't tell whether it was the blunt force trauma or the asphyxiation ultimately that caused the death. They don't know where it happened. Was it the bed? Was it the bathtub? They don't know how it happened. Was it a towel? Was there a weapon? Nothing was discovered. They don't have that. And why it happened certainly doesn't make sense. But yet you're supposed to believe them as to who it happened? Because it's convenient? And because they've eliminated every other suspect by questioning the homeless man for 6 minutes and he said, I had nothing to do with it. Okay, bye, thank you. They didn't vet the construction companies like they did with the list that Keith Ory gave them. Please, what about the people that were fired so that Keith Ory could come in? What about them? What about the men Shanti had an affair with? We didn't hear anything about him. We know that this place is within a mile of proximity to RMC, which is constantly seeing an admission and discharge of mental health patients walking through the neighborhood. There's a homeless problem downtown Orlando. This is right outside downtown. There are parks and lakes all over the place, and the neighbors tipped everyone off that there was a problem. That's why the detective looked into it. She just didn't look into it good enough. Because they had their man, didn't they? Yeah, what are you talking about? Confirmational bias. That's what this is. Gotta be the husband. So, we take that belief, and then we take this earring on the nightstand, we take a missed text message at 6 in the morning, we take a man who sleeps sometimes in the garage. Detective Sprague would have you believe that that's where he always slept, and all the stuff about sex and stuff was just nonsense because she believes it was a broken marriage, a marriage on the rocks. Well, what threw that on its head? Because she had to admit that she was wrong, that David was sleeping in that bed, and there is evidence consistent with it because his blood from the sores on his back are all over that bed. More so than Shanti's blood. 2 specks versus how many specks? And we know that his clothes are all upstairs in the closet. We know that no one else suggested that he was banished to the garage. Samantha, Lori, the other friends, no one said anything about that. No one said anything about any angst between them that they thought arose to the level of concern. No one saw any evidence of abuse, current or past. And that's evident. This was entered into evidence. This is Ralph Colacci's report. You can read it, but it's got some good language in here. This was at the time. There's no history of domestic violence, and there's never been any law enforcement calls out to the apartment. Please take this back and read it. And the other thing that it has in it, and Detective Sprague didn't know until what? This case? That these reports were written? Well, they are written. And it's documented proof that she poisoned the well because we know that that investigator Colacci wrote this report before his shift ended around 10:30 on the 24th. And this was written up before Detective Sprague had an interview completed with David, any conversations with anyone else, no other investigation. And they've got it labeled a domestic violence attack. It's telling. It's telling. That have you believe that this was a slow investigation. He sat there for 16 hours, bared his soul to them, literally and figuratively, told them what he knew, told them what he saw. They asked him to guess. Go back and look at how that all came to be. You've got detectives sitting in a room asking someone to guess, what do you think happened? How do you think this came to be? And because he gives a theory, they marry it to him like it's gospel. And now they hold him accountable for this as this is his version of events. And they're slaying him because it's inconsistent what they consider the physical evidence to be. And he's not crying enough. Gotta be the husband. They let him go. Let him go. For 127 days, they searched and they did their due diligence, right? Well, no, they just kept going back out to the house to continue search warrant number 2, search warrant number 3. A month later, they're still collecting things, blood. We think we missed the blood. We think we missed the bed. The significance, the sheets. Well, it was staring them in the face from minute 1. And what happened on the 24th? At 7 o'clock in the morning, they released David, a free man, and they released the property to him along with all the contents without restrictions. So someone going into this place and touching it, cleaning, moving anything at that point is not evidence of a crime. It's evidence of going into your home and cleaning up this absolute mess that was made by detectives. Executing their search warrant, cutting things up, flipping through things, spraying things down, dusting things down. I mean, so you take valuables, your valuables out of the home when you move in with your mothers, so you're concealing evidence? The ring, the ring, the ring. The ring was never missing. If you listen to the exchange in the interview, David confirms that she has a wedding ring. He talks about something else being said. He certainly doesn't say, I'm positive she was wearing it that day. He doesn't. The mere mention of the ring And the fact that they went out and searched high and low for it, supposedly, is a bit ridiculous. Because you've got two CSI techs who took hundreds of pictures. Pictures of everything. Some things it was even tough to tell why it was significant. But not only a picture of it, but a close-up of it, and another close-up of it, right? But we got bloody slats, we take pictures of them, we go collect them. We know the significance of sheets. We have talk about period sex. We have a hastily made bed. We have suspicion that the attack happened in the bed. But we don't take the sheets, we don't take the slats, we don't take the bed. But we're supposed to give her the creeps that she did an animal search and didn't just miss the ring. Well, we know David didn't have it because they stripped him naked. And he didn't drive himself there, so it wasn't on him. So it was there. They didn't photograph the drawer, they didn't photograph the ring boxes that day, they didn't photograph the inside of the ring boxes that day. They didn't. So you can't trust that it was done, because it's not in evidence, and her testimony is unreliable. A great deal has been made about the lack of movement of Shanti from 11:30 at night, and so the significance that her phone did not move from 11:30 till 6 in the morning. But the attack happened later on in the day, so how do we get to the fact that the phone didn't move from 11:30 at night? Does that fix the time of death? No, because that doesn't work with the timeline. We heard from the medical examiner, that's probably 24 hours before his exam. So we are talking the morning of the 24th. About 24 hours is mid-morning when David is out walking, and he's seen out walking, by the way. We know slight rigor. We know the blood pooling hadn't started it. It was not fixed. Kalachi was able to pinch, and the blood was still moving. So we know that 6 to 8 hours from that 5 p.m. So if you do that math, you know, the window is in that range of like 9 to 12 in the afternoon when he was gone. He was seen by a neighbor, and she didn't see him at 11:50. Go back and look at your notes. Go back and look at the evidence. She checked out at Publix at 11:50, and she saw him on the way to Publix. So it was earlier in the day. So there's a little bit of a misstatement as to the sequence there, as to how that came to be. She checked out, oh, now she checked a timestamp. She had a receipt. She knows she went to Publix, went shopping, and checked out. So when did she see David? Earlier in the day, and it was closer to 10:30 or 11. Woodyard says that the phone tracked steps, and the phone didn't move, so therefore Shanti didn't move. And how do they build that case? Because they go about presenting a handful of witnesses to say, Shanti's a really strong businesswoman, attention to detail, prompt answering calls, this is her thing, this is how she does it. Okay, believe me, 100%. But that's not 100% of the time, ladies and gentlemen. There are exceptions. People have off days, and there are times when we are not willing to answer a work call, especially when it's not urgent, right? Just a text message with a question about a fee. So, if one has a broken tooth, and one who's experienced dental pain could be excruciating. You know, like somebody stabbing you in the face every time your heart beats with an ice pick. You know, that's the kind of pain you're talking about. Kidney stones, childbirth, tooth pain, you know, that's it. There's no evidence because they didn't submit anything through the medical examiner or nothing, because she was certainly tested. Toxicology reports. What do people do when they're in pain? They take pain meds. What do pain meds do when people are on empty stomach? Because we have no evidence as to the contents of her stomach, we have no evidence of the contents of her blood. So if you want an explanation as to why somebody is going and falling asleep and not answering their phone, if you want an explanation why someone might take a slip and a fall in the shower, there you have it. It's a reasonable explanation. We know the tooth is broken. We know she had an emergency appointment. We know she didn't make it. So which is it, ladies and gentlemen? Is it the 11:30 stop time the phone? Is that the time of death? Or is it before 6:58? Because there's no way she wouldn't have, Apple phone, by the way, text message. Oh, I can see, I can read it, you put it back down. 2018, that's not registering a step, and that would be pretty safe. So, where does it leave us? It leaves us with the other witnesses. It leaves us with Samantha Adams. It leaves us with Lori. It leaves us with these other folks who come in and say, I was around enough. I never saw anything. Lori hung out with David and her husband together. They went to dinners. They hung out together. They went to a concert on New Year's Day. This is in 2018, really close in time. No suggestion whatsoever there was a problem in January. They hung out in 2017 during the hellish renovation time, right? And still no trouble. No cause for concern. But the ring, because Lori's seen the ring. When Shanti got engaged, that she ran around and she showed it off to everybody and she posted it on Facebook. That's what everyone recalls. Well, so what? Who wouldn't expect such a thing? It's a joyous occasion. It's a beautiful ring. They're happy. Wearing a ring, by the way, is a sign of a happy marriage. But none of these people also were privy to the morning routine, to the evening routine, to the shower routine. No one was in there for that. And no one knows where this ring was on that day. And David sure as heck didn't say that he knew for sure that when he saw her that the ring was on her finger. So it's a bit crazy for both the prosecutor and the lead detective to stand up here before you and suggest that he pried the ring off her cold, dead finger. And that's what he pledged he was going to prove to you through the evidence. No injury to the finger. There's no evidence that he sold the ring. He didn't destroy the ring. He sure as heck didn't need the money. The ring was worth $10,000 to $12,000. So what is the point? What is this supposed to suggest? He even sit in the interview and say, her ring was missing. She must have been robbed. He must have been burgled. No. He didn't offer up any explanation to try to deflect or to point them away. And because they said it couldn't be a fault, they put together a false choice, right? If it wasn't an accident, then you had to have killed her. Which was it? Okay, so you're telling me it wasn't an accident, and if it wasn't, I must have killed her. So now you're giving me an opportunity to say why I killed her. All that time, he sat there, and he did not make any admissions or confess to any crime. He answered their questions, and because they didn't believe him, and he didn't cry enough, he must be guilty of murder. Well, that's not how it works. The government has the burden of proving, beyond the exclusion of every reasonable doubt, that David Cooper-Tronnes committed this murder. If you believe it's a murder, if you believe that they proved that it's a murder. Because when you go to the point of the things that they missed and the things that the ME couldn't tell you certainly, it still leaves the possibility that this was a fault. And it isn't a forced doubt. It isn't an imaginary. You know, reasonable doubt instruction. Let's go over it right now because it's. Speak of a reasonable doubt is not a mere doubt, a speculative, imaginary, forced doubt, but if in considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one is not stable, one but which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. So what is that talking about here? You talk about stable or wavers and vacillates. The state puts forth circumstantial evidence. Certainly, you can sustain a conviction on competent circumstantial evidence. I don't stand up here and suggest that you can't. But you are not here to play detectives, like we talked about. You're here to determine if they've proven their case. So you can make reasonable inferences from the evidence, connect the dots, so to speak, right? What you can't do
is take these leaps from dot to dot. Because they're asking you to make assumptions that are not reasonable. They're asking you to adopt these unreasonable assumptions and consider them to be evidence beyond the exclusion of reasonable doubt. Well, if you picture the floor and the foundation where the pylons are so far apart and it's not stable because of waves and vacillates, that's the idea of this. There's too many gaps, too many leaps that you as a juror would have to take in order to consider this evidence beyond the exclusion of every reasonable doubt. And that's why, in going back there to deliberate and considering the evidence, that they've fallen woefully short. If you look at the rush to judgment, the investigation and stuff, the things that they missed, they pick up sheets. There's a leaf in the sheets. There's a leaf. What do? They throw it out. Do they take the leaf? Do they take a look to see if it's native to the property? Do they examine it to try to figure out, could this have come from somewhere else? It's on the sheets, it's relevant to the case. No, they disregard it. Why? Because they had their man. They had their man. The 24th, the 30th of April, the 24th of May, August the 29th, they come to the house at his mom's where he's now living, and they find the ring that's not missing. The aha moment. We found what we've been looking for 127 days. Well, with all due respect, you were looking for sheets and you got pictures of them. You were looking for slats, you got pictures of them. They didn't collect any of those things either. We don't even have pictures of these rings. So we're really supposed to trust the fact that they had them and that they documented them the way they said, or there's some confusion, because there was no continuity in this investigation either, right? Because OPD has this policy like, tag, you're it. Forget about the left hand, know what the right hand's doing. Because instead of waiting for CSI Crosby to come back with Taylor, they rush out to the scene with another CSI cat, Monroe, right? And she doesn't connect the dots because she doesn't test the lead, she doesn't do anything like that. She goes about her business. It's the lack of care. Dr. Utz, consummate professional. I mean, he gets up there, he delivers the evidence. He didn't stretch anything. He tells you that maybe the scrapes were post-mortem, that they could have occurred after the fact. He describes the light rigor, how rigor would have gone, setting and passing when he was doing the examination. That's how he figures conduct. Certainly, that wasn't considered by his other officers when they were coming up with this theory that she was slaying or attacking or whatever. Because it doesn't fit with the evidence. This is all just trying to force a timeline because they need to be able to put the time of death at a time when they know David's in the home, because they know he's outside the home at other times, and there is a reasonable explanation. And somebody else came into the property. Somebody else did this. And while he ruled homicide and the cause and strangulation and blunt force trauma, what he couldn't testify was to who? Who done it? That was left to Detective Sprague. Detective Sprague had all the answers on April the 24th. So, where's the smoking gun? His explanation doesn't make sense about what he saw, how he saw her when he walks into the bathroom on the worst day of his life, that he doesn't account for the exact proper position or clarifies things about that, or there's not enough water on the floor. What's the interview again? He certainly says that water did not splash out on the floor. Any explanation? Come up the stairs, your water trickling through a wall, you go around the corner, and one is encountered through a small doorway, an unconscious spouse, hunched over the edge of the bathtub, head down to the bottom of the tub, water's running full speed, he turns the water, and what does the tub look like? Look at the pictures, because what he describes is seeing rose-tinged water, right? He picks up his wife, her hair's wet, her shirt's wet, her short's wet. Makes sense. Is he really sitting there and examining this with such care, just like he's walking around all day long looking at his watch so he can get accurate timestamps, just in case later on he's got to account for everything minute by minute? Because that's what happened here. You ask questions to somebody who doesn't have the answers, and then you make false assumptions based upon the answers given. Once again, we're back to confirmational bias. The husband did it, his explanation doesn't make any sense. Except that it did. All the stuff did make sense. Why he was sleeping in a separate room, that he did have money, that the show was going to be taking things over. Everything was looking up. All of that they shared was good. But because he walked around in places where the cameras didn't work, that's on him. We know that this is his routine. Being weird and being awkward is not a crime. Being socially retarded is not a crime. Being awkwardly emotional is not a crime. What's wrong is drawing these dangerous conclusions from it when it's not supported by the rest of the evidence. Because if the strongest piece of your case is that he's not crying enough and there's not enough water on the floor, then that's not proof beyond a reasonable doubt. And it's why they needed 3 search warrants, plus another. It's why, to this point, they don't know where it happened, how it happened, why it happened. That's why. That's the reasonable doubt. Because the evidence doesn't rise to the level of proof beyond a reasonable doubt, except for the fact of proving up that she is dead and she was shot in the feet. If you believe it's a homicide, take a look at the second-degree murder instruction or the elements of it, and ill will, hatred, and lack. Some of that's important. But element number 2 of second-degree murder, element number 2 of manslaughter, so they have to prove that it was David. All of them require that as a separate element. So unless they can check that box on any of the defense, it's a straight not guilty, ladies and gentlemen. And this is a tragedy. You've got a little boy sitting in the courtroom, lost his mother. You've seen me throughout the trial. I know you're aware of it. I know that some people paying careful attention to Mr. Cooper-Tronnes, looking for certain things. I don't know what you're looking for, but trials are not about emotion. They're about evidence. You can't prejudge him because he didn't sit here crying to your liking, just like they shouldn't have prejudged him because he didn't cry to their liking. Go back, read the evidence packet, look at the law as a judge gives out to you, review the reasonable doubt instruction, review the weighing the evidence instruction, and think about how Teresa Sprague presented herself in this courtroom at interview. And think about how she steered this ship. And one way, blinders on the whole time. Rush to judgment, confirmation of bias, sloppy investigation, lacking evidence, lacking an abiding conviction of guilt. Considering the interview, instruction, please. You're about to watch a recorded interview that contains opinions and statements by Detective Teresa Sprague, and Detective Barbara Sharp to David Cooper-Tronnes. These opinions and statements are pertinent only to explain the reactions and responses they elicit. You are not to consider these opinions and statements by the police as true, but only to establish the context of David Cooper-Tronnes' reactions and responses. Likewise, the statement claimed to have been made by the defendant outside the court and has been placed before you. This was a statement made by David Cooper-Tronnes, not claimed. It's all the good work yourself. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. So, when the questions were asked in the manner they were the answers actually statements of fact, or were they truly just guesses based upon the questions that the officers were asking? And that's my point. When they asked, what do you think happened? What would you guess? You can't then just marry into it and consider it to be, a BS story. That he had all this time to come up with, and that's the best he can come up with. Well, you better come up with something better, because people are going to think you're not caring, you're not remorseful, and they're going to come after you for first-degree murder. Well, here we are. In making this determination, you should consider the total circumstances. How many hours he was at the station, what he was wearing, what he was eating, what he was drinking, the stress that he was under, the trauma that he was under. To explain some of the confusion, really? Whether when making the statement, when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. It was certainly voluntarily made. The question is, are ultimately the individual statements a result of a free and voluntary interview, or is it the manipulation that they are so adequately trained to employ in investigation techniques? The government's the one spinning here. The government's the one taking the insignificant and stacking them into a pyramid of inferences and asking you to make the same assumptions. The jury is bound by the law that the judge is going to give you, and I'm confident that after carefully deliberating and reviewing the law and spiritedly deliberating on the facts, listening to each other, a spirited exchange of ideas, that you'll come back and return the only just verdict in this case, and that's a verdict of not guilty. Thank you.
Thank you, defense. State.
Thank you. Shanti Cooper-Tronnes is telling you what happened to her. You just have to listen. Shanti Cooper-Tronnes is
Hold on
telling
one second. I'm sorry, State. Terrible time to interrupt, but it's going to be bad for their comfort if I don't take a break. Will you follow the deputy out for a minute? I need you to finish your lunch forms, otherwise you're not going to eat until 3. So I thought you were already finished with it. I apologize for this. State, I'm sorry for that. We're going to be in recess just long enough for them to finish filling out the forms. Again, state, sorry for my terrible interruption, and whenever you're ready, you may proceed.
Shanti Cooper-Tronnes is telling you what happened to her. You just have to listen. Look at the position her body was fixed in. Her legs nearly straight, both in front of her left arm down by her side, her right arm sticking out at a 90-degree angle and sticking up in the air. She is telling you how her body was positioned when rigor set in. The blood, she is the source of the blood in that apartment that is pertinent. Now, there was discussion about the sheet that a private investigator collected, and we'll talk about that later with other people's blood. What's important about that is who thought that was important to collect, not what was on it. She is the source of the blood. The blood on that wood frame of the side of the bed that has been wiped clean above the metal L bracket is telling you what happened to her, who did this to her. The blood hidden behind that L bracket and beneath it that dripped onto the wood slabs, beneath it is telling you who did this. The blood on the carpet, the copious amounts of blood on the carpet is telling you what happened to her and who did it. The blood on the mattress padding, the copious amounts of blood on the mattress padding, is telling you what happened, when it happened. Dr. Utz told you about the bleeding that would come from head wounds. That blood is from her head wounds. That mattress padding that the defendant says he was using to prop her neck was completely underneath her body, from head to toe. To prop her neck. The towel that the defendant said he was using to wipe her, that was underneath the mattress padding, that was underneath her, is telling you what happened to her and who did it. The defendant said that his wife was too heavy and too awkward to move. 6'2", 190, 195 pounds, and we'll see pictures of him again to remind you of what he looked like then. Too heavy to move, awkward. I had to flip her over face down, face up, half the way from the bathtub. But now he's lifting her entire body up to put a towel underneath it and to put a mattress padding underneath it, yet above the towel. The blood on her face is telling you what happened to her. As Teresa Sprague testified yesterday, you can see it for yourself with those pictures. You do not need to be a blood spatter or blood pattern expert to see the dried blood on her face running down the way gravity, one of the four physical forces of nature, would have it run. That's because she was face up as that blood dried, running off of her face after it was smashed in by the defendant before he strangled her. She is telling you what happened. Her body is the best evidence in this case, contrary to how our evidence was characterized by the defense. She is the best evidence. Circumstantial evidence does not lie. Circumstantial evidence does not fail to remember. It does not misremember. It doesn't have problems seeing through thousands of leaves on a tree like in My Cousin Vinny. It doesn't get drunk. It doesn't get high. It doesn't get accused of murder. There is a jury instruction that you will hear, two of which are pertinent in this analysis. One is does the testimony of somebody fit in with the testimony and the evidence with the rest of the case? The The defendant's statement is inconsistent with the forensic evidence in this case. There's no way to go around that, and we'll go into that. Does a witness have any interest in the outcome of the case? Absolutely. When he's making those statements to the police, he has an interest in not being accused and convicted of first-degree murder. So those are the things you must take into account with his statements. Why do his statements not fit in with the evidence? As opposing counsel just told you, not my words, what he just told you. Dental pain can be excruciating. Now we go down those Which Way books. I don't know if any of you are even old enough to remember these Which Way books. You read a little passage, and then you chose, and it tells you go to page 42, go to page 89. Well, the dental pain is either so excruciating that this businesswoman is not going to return texts, not going to return emails. We haven't talked much about those in the first two parts of the closing, but in evidence are her April outgoing emails. She was not outgoing any emails that morning. It's just so excruciating she cannot perform work, and the suggestion was made maybe she slept in. All right, so that's page 42 of the Which Way book. Page 89 is the defendant telling police she was kind of hemming and hawing when she came down for not one cigarette at 7:25 or 7:30 in the morning, or her second cigarette a couple hours later. She's kind of like, I don't know if I'm going to go. Which one is it? Is her dental pain so much that she cannot answer her texts and her emails, pick up her phone and get some steps with it? Or is it not a big deal? We're going to power through this. I know I made an emergency appointment, but we'll let it go. We'll do it another day. It's just a cracked tooth. So let's talk more about this. They were never more in love at this point in their lives. The surgery and the hassle that comes from recovering from surgery, even laparoscopic, which is what it looks like on her body she went through, is not fun and not easy. But a week or two earlier, Samantha Adams was done serving as her personal assistant, nanny, whatever. So now there are extra things that must be done. Jackson still has homework. Jackson still needs to get picked up and dropped off at school. There's all these things that somebody is getting paid to do for 20, 21 hours a week. That is no longer there. The defendant, sure, he wasn't working outside the home as we've described it in this trial. He wasn't working at all because construction had been halted on the house. So regardless of whether one cares whether he was working outside the home or not, independently wealthy or not, he was not doing anything. So if we're in as much love as we have ever been in our lives, Shanti Cooper-Tronnes is telling you the truth about their relationship. And so is the defendant, because he wasn't going to take her. That apparently was not in the plans. He's no longer being the GC, general contractor, over his home renovations. He's just playing with the dogs all day and picking up leaves and sweeping the pool 2 or 3 times. Why isn't he taking her to this dental appointment? Why isn't he turning the car on early and putting the air at her temperature that she likes? It's his words during the interview, not anybody else's, that she's hesitant about oral surgery. Oral surgeries, those are big words. Anesthesia? Really? She's going to go have anesthesia and drive herself home? It just doesn't add up. It doesn't make sense. The evidence in Shanti Cooper-Tronnes is telling you what was going on that day. She was dead. She was not going to the dentist appointment. Let's talk about that timeline. Yesterday was a long day for everybody. I agree. There's no good way to spend 6 hours of interview. I can't put one in at a time and then call another witness, put another hour in and call another witness. It was a long day. We start a little after 9:30. Of course, you're told 9:30 every day, right? Doesn't happen. 9:30 till about 6:30 yesterday. 9 hours. But we had a morning recess. We had an hour and a half for lunch. 3, maybe 4 afternoon recesses. And still think about how long of a day that was. The bulk of a 6-hour interview. When you're thinking about 9 hours, I want you to think about yesterday or whatever day of the trial you felt was the longest. 9 hours. And that is what his time frame is for himself that day. I woke up around 6:45 or 7. I called 911 shortly before 4 p.m. That's 9 hours. 9 hours that we're picking up leaves. We're going on walks by ourselves, which is Jacqueline Spence's testimony. And I submit to you, if she did not testify, she went to Publix for 80 minutes, as was suggested during arguments. That actually puts us back into his time frame of 10:30, being somewhere else, doing something else. So the evidence is what the evidence is. It's your recollection that controls. But we're going on personal walks. Then we're taking the dogs for a walk, like the pre-walk, because he's going to go work the dogs, which I guess is different than walking the dogs. There's walk the dogs, then you work the dogs out at the park, and then you come back and you clean the pool again and feed the dogs again. Ladies and gentlemen, that's not 9 hours. These are things that people with outside jobs or work from home jobs have to do on their own time in evenings and weekends. It's not 9 hours. She's telling you what happened to her. So is all this evidence, the timeline. Drawing inferences is not playing detective. I've already told you what the jury instruction is about evaluating the credibility of witnesses. If you don't believe any part of what he said to the police, you can disbelieve everything. And literally everything except for the rigidity of her jaw and her tongue being between her teeth should be rejected based on the physical evidence in this case. Their argument could have been about anything. Couples argue all the time. It does not have to be about money. But what the physical evidence shows is multiple blows to her head, to her mouth, bruises on her breasts, bruises on her arms, bruises on her torso under her ribs, and her being strangled. It's a very intimate, not quick way to kill someone. The sheets, again, yes, ideally, the Orlando Police Department would have collected everything on this first go-around. It is, in part, because of statements that were being given to them about a bathtub being the place of death, but it would have been nice if they had collected everything. But that doesn't mean Shanti Cooper-Tronnes wasn't murdered. It doesn't mean that the defendant wasn't the person who did it, because that is still what the evidence supports. Those sheets that were on the bed, that were said to be taken off the bed Monday when Jackson went to school by the defendant's words, these sheets were taken off the bed with the mattress padding, washed and laundered about 4 hours and 40 minutes into the interview, washed and laundered, and put away and folded. Those sheets were not, and somebody believed these sheets were important enough to be collected from the home by Billy Lane. That's what's important, is somebody thought they were important, and that somebody is the defendant. Argument about rush to judgment. 127 days is not exactly a rush to judgment. His statements were inconsistent with the evidence. He could very likely have been arrested that very morning had they been in a rush to judgment, had they been in a rush to make an arrest. Defense attorney argued during closing, quote unquote, the crime scene makes no sense. The crime scene does make no sense because it has been altered. Where her body is found with her arm sticking up, straight up in the air, that's not how rigor mortis works. It doesn't, her arm was positioned in that way when it got fixed, as was her body, as was her legs. That's what the testimony is from Dr. Utz. There's that. There is the mattress padding underneath her. There is the towel underneath her. There is the water all around the significant blood stainings by the side of that bed. There is the blood that was wiped away on top of the rail by the defendant. Nobody else. Did he mention wiping the blood away on the top of the rail in the statement of the police? No. He mentioned changing the sheets. The period sex got everywhere. He just didn't mention it getting on the rail, but yet we know there had to be blood above what is visible because it luminesced, it was diluted and wiped away, and there was blood on the metal L bracket behind it and beneath it, and even on the bottom dimension of it, and then on the 3 slabs. The fact that it did not drip onto the carpet, that's a matter of physics. We know that there is blood on that bed rail and on the bottom dimension of it. What we do know is the 2 cubic yards or so of carpet that was collected from having blood on it goes right up to the edge of it. So when we hear arguments about, well, where did this happen? They can't prove where this happened. First of all, that's not an element of the crime. But second, Shanti Cooper-Tronnes is telling you where it happened. It happened right there on the side of that bed. Whether the blood from her face dripped down onto that wooden blood, the blood on the side of the bed rail, or whether it was the defendant dripping it there after strangling her as she bled down her face from the wound on her cheek, we know her blood dripped onto the side of that bed frame. We know her blood is significantly present right there at the side of the bed. We know she had an earring in her left ear. We know the matching right earring was on the nightstand. It is not inference upon inference in pyramid schemes like a Ponzi to stack to say it is very likely she was taking her jewelry off and going to bed. She's in night clothes, and one earring's out, one earring's in, phone's on the side of the bed, or very well perhaps early in the morning when she woke up. But she did not go down and have cigarettes at 7:30 and 9:25. She's not going to ignore her work emails and phones. It's not because her tooth hurt so much that she canceled the dentist appointment. What we know is that scene was altered. That water did not come from Shanti Cooper-Tronnes. The water around the bloodstains to the southeast and southwest of her and on that mattress padding and on that towel, that water, she didn't do that. It didn't come out of her body. She didn't get it from a source of water. The only person who could do that is the defendant. He is the source of that water in the living room. And there's no water at the time the police is called on the bathroom floor, trailing between either route around the couch, whether you go to the left or the right, to where she is found. It's not a pyramid scheme to ask you to infer that water was moved earlier or so carefully that there was no water between points A and B. And I'll remind you, and we'll see the photographs, that brown rug in the bathroom was balled up in the side. That's a really strange place for it to be because, number one, he hasn't mentioned it, and number two, he's the one that needs leverage to pick up his wife out of the bathtub. And with no rug there, it's just tile. So yes, the scene is weird. If you were asked to draw the conclusion that she was killed in the bathroom, that would be a weird conclusion for you to have to draw, given all the blood in the other room, given the lack of blood and water trails between points A and B. So yes, the scene makes no sense, but that's because the defendant altered it. He wiped down the bed rail. He brought water out to those blood stains in an attempt to clean it up. The shower, it was dry. That's the testimony from law enforcement. When they arrived at the scene after he called 911, it was dry. It was not wet. The bathroom floor was not wet. Yet it had that tinge of blood on it. And then, after it was luminesced with the chemicals that bind to the blood proteins, it's not just in the tub. It's as high as the tiles go. It's everywhere. His bloody palm print is there. It's as if somebody showered to clean up. Whatever happened, there is diluted blood everywhere in his bloody palm print that luminesced with the blood and was lifted. Yes, the crime scene doesn't make any sense compared to his version of events. That's because his version of events did not happen. And when his version of events did not happen because of his credibility, you can disregard all of his statements to the police. 16 hours at OPD. That is a long time. But during that time frame, he was told by the detectives what they believed happened. And ironically, what the detectives said they believed happened based on their training experience was what Dr. Utz said happened based on their training experience, his training experience. But that's not what he was telling people, if you remember. That's not what he was telling people how his wife passed. Not that somebody had come in and murdered and strangled her. It was a different version of events when he had to tell people what happened. He may well have been sad. People regret doing things. Think of every mistake everybody has ever made. People regret it. They make mistakes. Some mistakes are bad enough that you cry. Some mistakes are bad enough that you feel bad about. He may well have been very sad that she was gone. That does not mean he didn't kill her. She was brutally attacked and then strangled. That is indicia. That is evidence of an angry, angry, angry moment. There's been talk about CSIs being in training and detectives being in training. The defendant was in training on how to murder people because he made simply too many mistakes. There's been discussion about cleaning products. Nobody's suggesting that cleaning products were used anywhere. Nobody testified that they walked in and smelled bleach, ammonia, whatever products are out there. Nobody said that. What they said is it looks like it was wiped up with water. It's diluted. Think of how much time he had, regardless of whether it was first thing in the morning when one earring was in her ear and one was out, or the night before. Think of how much time he had to do whatever he wanted to do about the scene. And it ultimately proved to be too big of a problem. There was too much blood. It wasn't coming up out of the carpet. She had too many injuries. He ran out of time. 3:50 p.m. was time to start making arrangements for Jackson. And again, they're in the best stage of their relationship. They've never loved each other more. This is perfect. He hasn't checked on her tooth all day long. I get that you don't want to be bothered while you're working. Anybody who worked at home through COVID understands this. You don't want to be bothered by your pets, your kids, your spouse. I get it. But she has a broken tooth. Speaking of our 90-minute lunch break yesterday, there's no mention of a lunch break for him. No mention of, sweetie, would you like something not taco-based for lunch today? There's no lunch in his 9 hours. There's no lunch in her 9 hours. He was in training as well, and he did not do a good job of cleaning this up. The attack by the side of the bed is no hunch. She's the source of blood. She's the source of blood. It's all right there. There is blood in the bathtub, but there's no indication that she was there. If she was there, as he describes, left side submerged, how does her right arm get into rigor straight up in the air? How do her legs, one of which is said to be bent, the left leg bent on the side of the tub, How is it in rigor and near 180 degrees straight? It didn't happen. And when somebody says things that aren't true, you can disbelieve everything they say. Those cutouts go right up to the side of the bed. So there's been talk about spatter. Gary Crosby, I would submit, said low velocity things like blunt force from hands or something like that is not going to produce spatter. It's not like a bullet wound. This isn't a Quentin Tarantino movie like Kill Bill where somebody gets cut and there's just blood everywhere. But there is blood in front of where she may have been sitting there. Because remember, her sitting there or standing there, she has one earring in, one earring out. The blood is there. Whether it dripped with any velocity sideways or just dripped straight down, we'll never know because there was so much of it, and then it was covered up by her, covered up by water, covered up by a towel, covered up by a mattress pad. There was no reason to go into the main house. The defendant said that this occurred in the bathtub. There was no indications of a break-in. There was no indications of anything being taken, really, except for her ring is missing. And I'm not going to stand up here and argue about the significance of the ring to you. That's been done plenty. But anybody with a diamond engagement ring understands what I'm talking about. It is not going to be tucked away in some obscure box that nobody can find except for the defendant. The finances are in evidence for you to just consider. If we don't put things in evidence, then we get told we didn't put things in evidence, there was a sloppy investigation. I am asking you to focus on what matters, and that is Shanti Cooper-Tronnes and her body and the surrounding scene is telling you what happened to her. It's the forensics and the forensics lining up against his statement that matters. Nobody went upstairs through that vacant house, went across the roof, and went in and killed her for no apparent reason, no apparent robbery, and then left. Imagine if I were prosecuting somebody other than the defendant for this. There's no signs of a break-in. There's no signs of an intimate relationship that would spark a sudden attack. There's no DNA from anybody else. There's no fingerprints from anybody else. I submit to you a high school student in mock trial could defend an accusation against somebody other than the defendant in this case. All the evidence points to him. His statement is inconsistent with forensic evidence. Towards the end, and before I go through the last few pictures, this is just a couple points about the argument that I'm rebutting. The defense attorney says, it leaves a possibility it was a fall. And then he hastily turns to the reasonable doubt instruction. He tells you about forced, speculative, and imaginary doubts, but left out possible doubts. The first phrase in that whole strew of four things, it's a possible, forced, imaginary, or speculative doubt. Everything that was argued to you about possibilities is not in evidence. It's not reasonable. I would submit to you, Dr. Utz didn't say the scrapes were after death. I would submit to you that the testimony was that it was at or near the time of death, but your recollection is what controls. Permission to publish different exhibits, different items from different exhibits, Judge?
You may.
The last thing before I turn to these exhibits is the issue of water not splashing out. That the defendant never said water splashed out. Even though you would expect that if his wife is completely submerged on the left side of her body in a tub that he claims is running up to where the top of the bloodstained rim is, water would have to come out. And remember, this is the same bathroom where the brown rug is pushed away by the defendant for whatever reason. The reason there was no water that came out is because she was never in there, and the bathtub was dry when law enforcement got there. Blood was transferred into there, but it was transferred into there by the only living person left in that home, the defendant. Turning to closing argument exhibit. The first image is from BK, and it's image 30. This is David Tronnes on April 24th, 2018. A 6'2", I would submit, strapping man with pretty well-developed back muscles who claims that he cannot pick up his 140-pound wife in an emergency. 6'2", built like that. Whether we want to argue about the perspective, that cutting of the carpet is very near the bed and completely consistent with somebody being struck at or near the time when they're getting ready for bed and has one earring in and one earring out. And what we see here on this bed rail, again, there's blood hidden behind here that OPD did not see, and blood beneath it, which OPD did not see on April 24th. But there's a reason that there's no blood above there, and that's because it was wiped away by the defendant. If he thought it was period blood, it wouldn't have been so important to wipe away. Underneath that L rail, Exhibit BN, item 58, you can see how it's pulled up on the bottom side of this rail itself, rather than dripping to the carpet. It pulls up on the bottom. And reminder, there was 3 wooden slats under there. BN 83, that's what it looks like when the metal is taken off and there's blood behind it that the defendant did not clean. From the movie that you were just shown during defense argument, BS, there's 2 stacks of new sheets. And we can talk about that in some length. Shanti Cooper-Tronnes was a woman who certainly liked to have a lot of different sheets, and apparently they're all white, and as we know, white sheets need to be changed and cleaned quite often. What the defendant would have us believe is that sex happens on Saturday night causing this horrific mess. They don't do anything about it. They don't use a towel for whatever reason in this instance to get his bodily fluids or get her period. They have sex again Sunday night. Again, they sleep in it that night. And then Monday morning, they're taken off, the mattress padding's taken off, and according to him in the statement, the sheets are laundered and folded. But yet the mattress padding remains. That mattress padding, I submit, would fit into a normal-sized washer and dryer. But it's not washed. And so now we're into Tuesday, and it's still just sitting on the ground, and Shanti Cooper-Tronnes and David Tronnes, the defendant, both of whom are equally available to wash this mattress padding, just don't. And what we have instead is a hastily made bed, which I would submit would look like a bed that I made, because I'm not good. No attempt to put the fitting sheets down, just hastily made bed is what we see April 24th when the police come in. That's because he ran out of time. BJ, item 71, these balled up sheets. Again, I'm not going to dispute that those should have been eyed on April 24th, but what's important is May 6th, they were taken away by Billy Lane because somebody thought they were important. 75, another image. BN 22, now they are gone, as well as some sheets beneath there. And again, you can see how many sheets Shanti Cooper-Tronnes and David Tronnes, the defendant, owned, and 2 more packs of sheets on the banister until there was 1. And she's not going to make sure that she has a mattress padding that is cleaned and washed immediately. BU, the sheets that are collected from Billy Lane, stains that are on them. Sure, there's explanations for the stains, his sores on his back, sex, so on and so forth, BX4. But whatever the explanation actually was, remember, Somebody thought it was important enough to have a private investigator take it away. BJ, image 112. There is that single earring. Ladies and gentlemen, you guys can glove up. You can open these exhibits. I didn't open every single exhibit for you because we want to be here 1 week as opposed to 4. But you are free to open up any exhibit you want. Check those 2 earrings. They are a pair. You're going to have a computer that's scrubbed down, can't connect to the internet to review all this digital evidence. You don't need to memorize it. There's the earring, there is her watch, there is her phone, among all the phones and computers and things of value that were not taken by any alleged robber. BJ 31, there is that other earring when she is lying there on the ground. Nobody at the time, as Detective Sprague testified to, could see her right ear prior to her removal by the medical examiner. Another thing to talk about, Dr. Utz said that those were not linear marks on her neck consistent with a ligature. So if it's not a linear mark, we can start ruling out the bathtub clothesline idea, that she was somehow clotheslined by the bathtub and somehow hit her head on every dimension, left side ear, both sides of her mouth, black eyes on both eyes. We can rule that out. Let's look at this mattress padding again and how much blood there is on it, how much water there is there by the nightstand. That is a tremendous amount of water for a tremendous amount of blood. It was not going to get cleaned up. Didn't stop him from trying. And remember, she is too onerous to move, but he completely put this flat mattress padding underneath her with a towel underneath it, which he used, according to him, to wipe his wife. This is what it looks like when somebody is beaten and strangled to death. You can see the dried blood. You can see it going down the way gravity pulls it. 6, 7 hours in a bathtub with her left side submerged, you do not have to be a blood pattern expert to understand that that is not what you would see. Here's the bathtub, and again, you're about to see that in all the dimensions there. You can start to see it. Everywhere is going to be luminescing with the blue. You can see that bath rug was pushed all the way to the wall by the defendant. She didn't do that. Why? The cleanup effort. Look at the bedding. That does not look like the bedding on April 18th. That does not look like the bedding of a meticulous businesswoman. Her ring is not on her finger. I will leave that to everybody who owns diamond engagement rings. BP 163, where is the ring found? With the defendant. BK 28. This is the man who about 17 minutes and 35 seconds into the interview, when he's talking with Detective Monfort, says he didn't have enough time to clean up and he apologizes for his dirty, filthy state. Does this look like somebody who is trying to perform CPR on his wife? There's no blood or water stains, diluted or not, on him. Image 31 on BK. He told Detective Monfort he didn't have time to clean up. He had just pulled his wife, the universal source of all that blood, and moved her, put the towel underneath her, wiped her with it, according to him, then put a mattress padding above the towel and got her, who was too awkward to move, on top of these items. His hands do not show any signs of blood. That is the laceration that Detective Utz, or Medical Examiner Utz, said went down to the bone. It's consistent with being punched. It's consistent with having a ring on. Does this rule out that a weapon was used? No. We didn't allege a weapon was used. We don't have to prove it. So either a weapon or a hand, whatever you believe is sufficient, but I would submit that is consistent with this man 6'2", 195 pounds at the time, with that hand and that ring doing that, and tearing her hair out, nearly pulling her ear off, strangling her to death. Ladies and gentlemen, there is no doubt to be had, reasonable or not. There was no break-in. There's not any indication of a break-in. There's not any indication when taken in the totality of the circumstances, as Dr. Utz says you must, when evaluating cause and manner, that suggests a fall. She was beaten and strangled for whatever reason. I would submit they were icy cold with each other in that video the defense just played for you during closing arguments. I submit she was icy cold. I'm not suggesting that people don't change their emotions throughout the day or day to day, but it did not support the conclusion that they were asking you to draw. Ladies and gentlemen, listen to the evidence. Circumstances do not lie. They do not get drunk. They do not get high. They don't misremember. They don't have vision problems. They don't have motivations or biases. Circumstances are great evidence. We are not asking for inference upon inference. I have laid out for you the inferences to draw, and compared to the defendant's statement, his statement is inaccurate compared to the forensic evidence. You can disregard everything he said under the jury instructions. It's inaccurate because that's not what happened. He killed Shanti Cooper-Tronnes. Listen to Shanti Cooper-Tronnes. She is telling you what happened. Thank you.
Thank you, State. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I'm about to give you. When we're finished and you go back to the jury room, you will each have your own copy, so you do not need to take notes of this. David Cooper-Tronnes, the defendant in this case, has been accused of the crime of first-degree murder. Murder in the first degree includes the lesser crime of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by justifiable use of deadly force is lawful. If you find Shanti M. Cooper-Tronnes was killed by David Cooper-Tronnes, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was second-degree murder, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune, and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from the sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before David Cooper-Tronnes may be found guilty of first-degree murder or any lesser included crime. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Shanti M. Cooper-Tronnes is dead. 2, the death was caused by the criminal act of David Cooper-Tronnes. 3, there was a premeditated killing of Shanti M. Cooper-Tronnes. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he's accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond every reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Shanti M. Cooper-Tronnes is dead. 2, the death was caused by the criminal act of David Tronnes. 3, there was an unlawful killing of Shanti M. Cooper-Tronnes by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it's an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Shanti M. Cooper-Tronnes is dead. 2, David Tronnes intentionally committed an act or acts that caused the death of Shanti M. Cooper-Tronnes. Every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It's to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. Let me try that again. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It's up to you to decide which evidence is reliable. You should use your common sense in deciding which evidence is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness' testimony agree with other testimony and other evidence in the case? 6, did the witness at some other time make a statement that's inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or the number of exhibits it's offered, but instead on the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It's entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of a witness. A juror may believe or disbelieve all or any part of evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It's up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it's set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or you're angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It's my job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such a lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, a necessary verdict form has been prepared for you. It is as follows. Starts with the state of Florida versus David Cooper-Tronnes. Has our court, has the case number, has the charges. Verdict, we the jury find the defendant guilty of first-degree murder as charged in the indictment. We the jury find the defendant guilty of the lesser included offense of second-degree murder. We the jury find the defendant guilty of the lesser included offense of manslaughter. We the jury find the defendant not guilty. So say we all, and then a place for a date and a signature line for the foreperson. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that discussions are carried on in an organized way and that everyone has a fair chance to be heard. It's also the foreperson's job to sign, date, and bring the verdict form back when all of you agreed on the verdict. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You're not to communicate with any person outside the jury about this case. Until you've reached a verdict, you must not talk about this case in person, through telephone, writing, electronic communication, such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules, I remind you, apply until I discharge you at the end of the case. If you become aware of a violation of these instructions or any other instruction I have given in this case, you must tell me immediately by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, other electronic devices, smartwatches here in the courtroom. The rules do not allow you to bring any of those devices into the jury room. The deputies will provide storage for you and watch over them and guard them while you deliberate. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have a question, I'll talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can, in writing or orally here in open court. During the trial, items were received in the evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Some of those exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any additional exhibits, please request that in writing. An evidence log will be provided to you. In closing, let me remind you that it's important you follow the laws that's spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For over 2 centuries, we have lived by the Constitution and the law. No one juror has the right to violate the rules we all share. Mr. Patrick Barnes, Kenneth Travinson, and Camila Alejandro Vasquez Leon. You 3 were selected, 3 of the last 4, as alternates because you were selected last year, the alternates. So your job is just about finished. If you have any, do you have any items in the jury room? None? Okay. Then if you will remain seated here, the remaining ones of you, if you will take your notepads with you and follow the deputy out for deliberations. Did you remember something that you have in the back? Yeah. What is it so the deputy can get it for you? Thank you. your consideration, your thoughts, your attention of this trial. Obviously, the job of alternates is incredibly important. You can imagine if we got to this place and there wasn't enough jurors to go back to the jury room for whatever reason, we would have to start the process all over again. So we have this safeguard where we bring in extra jurors so that we can call upon the alternates if that indeed is necessary. You're welcome now to talk about this case with anyone. You're also welcome to refuse to talk to anyone. It's completely up to you. You're welcome to stay or leave. If you stay and you can talk with anyone you want to. If you decide to leave, you should know that if you become curious as to what happened, you could probably watch TV, but absent that, you can also call my office and we'll let you know what the ultimate outcome was. Thank you again. And I sometimes have this conversation at the end with jurors. Everyone doesn't have the job that we have. Do make sure that you use the resources you need if you need resources for anything. And if you need to call our court administration, we can help you find that. And you can follow the deputy out. I think there might be some food and they'll grab that food too, but you'll be going that way. State defense, any objection to the instructions as given?
No, Your Honor. None, Your Honor.
And will you each approach, decide what evidence is going back and include the laptop if you're doing that, make sure there's no objection to that. After which case, after you guys agree to all of that, if you will leave your number with the court reporter, with the clerk so that we can contact you if needed. Do take the first hour and 15 minutes somewhere in there and allow yourself to go have some proper nourishment. I won't call you back before 2:15 or 3:15 so that you have enough service. We might call you to let you know, but we won't require you to be back before then. Otherwise, be within 15 minutes so that you can come back if there's any questions.
Does anybody object to me labeling what I used in closing as state rebuttal closing?
Defense, any objection?
Rather than 20 discs, what I wanted,
No,
I think it gets tagged in the record.
it doesn't. Yeah.
Yeah, there's contraband guns. Did anything get marked for ID and not put in? It was a couple of hard copies.
Let's go through that and make sure before it goes back to them. State defense, quite important.
State W, not submitted. The dog sleep line.
Yeah, that one, and then there should be photographs too. Going in.
Photographs collecting dog sleep line to the DV. And hard copies of the photos.
You said BB, I'm sorry.
Boy Victor. And then hard copies of the photos engagement ring, which was CF. No, that's C. Those are the only three that I have that were not.
We want evidence log.
I made another one. So I have everything numbered that was given a number.
We must not have ever put BB up here, did Photo of the deadline?
Yeah. TV?
Yeah.
Victor? Yeah,
You
I have it.
have it.
Bravo Victor?
Do you want it since it didn't come in? Right, you don't?
No, because I didn't
You didn't.
even talk about it.
Or release the
On the instruction plea of not guilty, I mistakenly had the state change the wrong sentence, thinking it was opposite of that. I reprinted copies, however, because of my wonderful secretarial skills, they've come out differently. Do you have any objection to that? Me going back with the plea of not guilty the correct way? It's going to have that. On the other side is going to have a manslaughter instruction. Any objection?
No objection from the state.
Okay, thank you.
Yes, I hastily added that must that you wanted, and I didn't notice that I had already put must where
Right,
people wanted.
right.
But then I thought, well, the other pardons have been outlawed, maybe she should just go on this one.
No. No, 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 no.
I have a total of 85 evidence.
All right.
And you have to use me and above.
Thank you.
they need to move their cars, and if everyone here, there's no one that takes public transportation, just for ease of the evening. Okay. Not- If it were me, I would not risk that.
Yeah.
Good evening. You can just sit back there, that's fine. I see you just kind of maneuver well, so. I received a question. I'm going to read it aloud, make sure that I'm reading it the correct way, and then I will attempt to answer it. The question I received is, can we have a more comprehensive definition of premeditation in terms of murder? That's the question as I understand it. There is nothing else for me to give you other than your information right now of what the instructions are. That is definitely the legal definition of premeditation. Switching the subject now that you're all out here, I plan on sending a menu back with you in about 15 minutes. It usually takes about an hour for the food to come at that point. I also want to talk to you. Is there anyone here who tries to get home on public transportation? Okay, not seeing any hands, good. The garage changes at 7. There's a lot of people here that says it's still open until midnight. I don't know that's true. I think sometimes mostly people try to move their car by 7 out of the garage next door. So I'm inclined to probably about 6:30 after you've looked at the menu, or somewhere around that time, I'm gonna have the court deputies allow you to go over there and move your car to where you want your car to be, and then come back up here. Of course, when that happens, also when the menus come in, you're not to talk to anyone about it. And of course, you stop your deliberations, just like I said before, until there's no one else in the room with you. And when you separate, even for that few moments to go get your car, not only, you can't talk to anyone about it, including, you won't have your information, I don't think. I mean, you won't have your phones, but you're not to talk to deputies or each other or anyone unless you're all in that room together talking about it. Other than that, you can't talk about it and you can't do any research. Right?
Yes.
Thank you. And then with that, you can follow the deputy back out.
There was
Yeah.
a follow-up question. I think some of us needed validation. They normally did it during lunch because we didn't want to be late. Is that something that's? Validation for what?
For the parking?
Oh.
Okay, we're gonna see if there's any way to get such thing, but they very well might be gone, but, we'll figure that out. Thank you. And you can follow the deputy out. Probably to 10 if needed. Just to give you my reasoning, I'd like to limit the accidental exposure now that they're in deliberation. So I'll probably keep them until 10 and bring them back like at 9. Any other questions, anything else?
Nothing from the state.
And also, we had an earlier question that we didn't call people back for. The question was, may we write on the exhibits? I sent them a note back saying no, and sent them an unopened pack of stickies for their convenience. Any objections, Dave?
No, Your Honor.
Defense? And we'll be in recess then. want to remind everyone in the gallery that it's incredibly important for decorum after a verdict. I absolutely understand that this is emotional for many people and for good reason, but you must do everything you can not to make anything audible, not to make any kind of facial expression when there's a verdict in. And if you don't follow those rules, the deputies will be taking you out right away. And in fact, there can be other things that happen from there. So it's really important everyone follows those rules. State ready?
Yes, Your Honor.
Defense ready?
You are.
And we can bring the jury out. Good evening. It's my understanding you've reached a verdict. Will you hand the verdict form to the court deputy, please?
State of Florida versus David Cronnes, case number 2020 CF 12472 AL, in the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida. Verdict reads, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. So it says we all, dated at Orlando County, Orange County, Florida, on the 18th day of October 2023, signed by the foreperson.
Does either the state or the defense wish to have the jury polled?
We do, Your Honor.
Juror number 493, is this your true and accurate verdict?
Yes.
Juror number 486, is this your true and accurate verdict? Juror number 142, is this your true and accurate verdict? Juror number 121, is this your true and accurate verdict?
Yes.
Juror number 88, is this your true and accurate verdict?
Yes.
Juror number 143, is this your true and accurate verdict?
Yes.
Juror number 624, is this your true and accurate verdict?
Yes.
Juror number 714, is this your true and accurate verdict?
Yes.
Juror number 481, is this your true and accurate verdict?
Yes.
Juror number 149, is this your true and accurate verdict?
Yes.
Juror number 273, is this your true and accurate verdict?
Yes.
Juror number 704, is this your true and accurate verdict?
Yes.
Thank you.
Ladies and gentlemen, I want to thank you again for your time and consideration of this case. I also wish to advise you of some special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that happen in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We've recognized for hundreds of years that juries' deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you this unique privilege not to speak to anyone about the juror's work. Although you're now at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. It's up to each one of you individually. A request to discuss your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It's up to you each individually to decide whether to preserve your privacy as a juror. And again, thank you, and you can follow the deputy out. Any legal reason not to proceed to sentencing?
Not from the state?
I can't express one, Your Honor. I don't believe we've got much option here.
All right, thank you. State witnesses?
Yes. Jeffrey Dow?
You solemnly swear and affirm the testimony you're going to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Can you please state and spell your first and last name for the court reporter?
Legal name, first name Norman, Norman, middle name Jeffrey, last name Dow, D-O-W.
Is there anything you'd like to tell the court? Please direct your comments to the court, not the defendant, prior to the court passing sentence.
Yes, Your Honor. This has been a long, long, long time for us to see justice done. What this has done to me personally, this was more than my stepdaughter, this was my daughter. And what I go through every day. It's hard to put into words, but yet I need to express. I suffer so much with PTSD. This has affected me so much that it withdrew me from my grandson. Because every time I thought of Shanti or my grandson, the last time I saw my daughter, we were together. So every time that I think of Jackson, it brings to my mind my daughter, and it upsets me. And all I can pray is that now that we can go forward from this day forward, and we can rebuild our relationship that we had. I suffer so bad when I was a happy-go-lucky person, laughed, joked all the time with everybody. Now, I am in constant anger. That, not really anger, but I just lash out at sometimes at anybody or everybody for no reason at all, because I am so angry and deep inside, hurt with the injustice that was done to my daughter. That's about all I mean, I could probably, that's all.
Thank you. Defense, any questions?
No, Your Honor.
Thank you, sir.
James Cooper? Jackson Cooper?
Are you each making a statement? Will you both raise your right hand to be sworn, please?
Do you solemnly swear and affirm the testimony that you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Jackson, let me start with you first. Can you go ahead and state and spell your first and last name for the court reporter?
Jackson, Jackson, Cooper, Cooper.
James Cooper, James Cooper.
And my understanding you go first?
Jackson.
Go ahead, Jackson. Just direct your comments to the court.
Your Honor, my mom was the best person I ever knew. She She worked a lot, but she never put her family over work.
Jackson, take your time. Hold on 1 second.
Early 2018, she was taken from me and my family. It's like a hole in my heart that I can't fill or fix. She didn't die peacefully. She did not deserve anything that happened to her that night. My family and I have been waiting for about 5 years for justice. I miss her so much. I would have never thought the day before was the last time I would see my mother alive. I miss the times where we would go to Universal, or just the simple times, like walking the dogs or going to the park. She was the best mom I could ever ask for. That's it.
Defense, any questions?
No, Your Honor.
Thank you, Jackson.
Your Honor, when Shanti and I were married, we tried for years to have a child with no success. It was an extremely difficult time for us, and we were about to give up when we got the wonderful news in early 2009. We did our best to raise him together. But as you know in life, it is not without its curveballs and heartaches. And when we divorced, as difficult as it was, one thing we never fought or wavered on was raising Jackson the best we could. He's tall like his dad, but he got his brains, his compassion, and his outlook on life from his mother. And her and I moved forward and continued raising a wonderful son. When this parasite came into our lives, he took something from us, and most importantly from Jackson. And what he took is not replaceable. It is something that I struggle with every day. He lost a good parent. It is still unfathomable to me what he did to her and what he put Jackson through. He knew and he saw firsthand how special their bond was, and he still tortured him and brutally ripped her from this world, our lives, and Jackson's. As I've struggled to understand, to this day, the only word I come back to is evil. Only evil would do what he did to her and Jackson when he had the choice not to do what he did. For every wonderful achievement he experiences, as young children do when they grow up, it bothers me as we experience these moments that not only is she not here because of this parasite, but that I have to think of what he did during these wonderful moments. Awards at school, great report cards, acting in the school play, and I don't know if that will ever change, but it makes me so proud to see him flourish, knowing she had an everlasting impact on him, despite what this parasite did. After today, her name will be spoken every day by someone who knew her and loved her. She will be remembered and thought of every single day because of who she was and is. People will know her, will look at him and know she is inside him and smile. And because of all this, she will never be forgotten, and she will always be with us. After today, this parasite's name will never be spoken again. Anyone who knew him will forget him. He will never be remembered or thought of after today. No one will ever call or visit him where he's going. He will be forgotten, and he will not even be a footnote in this world. If Your Honor does what she is supposed to and do what is right, and that will only be a fraction of what he deserves for what he did to her. Thank you.
Defense, any questions?
No, Your Honor.
Thank you. You both can return to the gallery. State, any other witnesses?
Reading an impact statement from one of her friends, Melissa Brzezinski. Thank you to everyone involved who has been on this long journey to see justice through for Shanti, especially to the jurors who listened with compassion and open hearts. It is hard to put 25 years of friendship, love, laughter, tears, and memories into a short paragraph of someone who you love so much. I met Shanti when we were in college, and she was exactly who she was described as: smart, diligent, ambitious, persistent, organized, focused, goal-oriented, and independent. What was explained was how she was strong, fun, social, loyal, authentic, but most of all, a loving mother and friend. She always worked so hard, often not getting to reap the benefits of her success because she was so intensely focused on building a future and a legacy for Jackson. As you can imagine, Jackson was the inspiration behind all that she was living for and building. There is a deep void with the loss of Shanti being gone. I often feel her presence, and most of the time it feels like her nudging me to do better, work harder, and focus, and I hope she keeps doing that. I miss her because despite our differences in personality, we were also very similar. She might be gone, but she will never die. She will live forever through our memories and through the great life Jackson is and will continue living. Jackson, your mom would have wanted you to always do your best. Look at life as beautiful and don't take anything from anyone. All of us are here in her honor, and you have an army of people that loved your mom that will always be here for you no matter what.
Thank you, State.
That's it, Your Honor.
Defense, any witnesses?
Witness, David?
I'll give them a chance to talk last. Do you have any other witnesses?
No.
All right. And then State argument?
There's only one sentence the court can pass at this point. No score sheet is required. The state will be waiving restitution and cost of investigations due to the sentence.
Defense?
I would agree with Mr. J's assessment.
Mr. Tronnes, anything you wish to say prior to sentencing? I think you just said no, is that right? Then in this case, CF 1812472, the court will adjudicate you guilty, will sentence you to life imprisonment with credit 1877 days, impose all the statutory required court cost fees, cost of prosecution, and state any objection to that being turned to a civil judgment?
No, Your Honor, and I believe the verdict form, if I heard correctly, the styling might have been 2020. It should be 2018.
Spence, it does say 2020 on the actual case number. Any objection to me modifying it on
No, Your Honor.
writing? I'm just writing it in blue pen and then initialing it. And that's, of course, with the minimum mandatory. Anything further, state?
Your Honor, thank you.
Spence? Sir, you have 30 days in which to appeal the judgment and sentence. If you can't afford an attorney will be appointed to represent you. Any appeal must be in writing. Any questions? Anything further, state?
Your Honor, if I could approach the DNA order.
Thank you. Any objection to the DNA order? Luck to you, sir. And the court will be in recess.